Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are continuing our rewatch of Ohio versus Toby Madden. We will be doing days 4 and 5 today, which will include closing arguments and the verdict. So get comfortable, settle in, and let's get started. All right. Hello, everybody. Welcome in. How's everybody doing today? It is Wednesday, August 12th, 2026. We are continuing our rewatch of Ohio versus Toby Madden. This took place in 2024, September 23rd through the 27th specifically. So we're going to be watching September 26th and 27th because we're going to do days 4 and day 5. It was a relatively short trial. 5 days, and Rachelle is the victim in this case. She was 50 years old at the time. This took place October 11th of 2022, and Toby is facing 2 counts of the Big M and felonious assault. Poor Rachelle was stabbed 55 times across her entire body: head, face, neck, chest, abdomen, back. We heard from the medical examiner yesterday, the forensic pathologist, and he said any number of wounds could have taken Rachelle's life, but the heart for sure, liver would have been another one. Her lungs, she had like 1.7 liters of blood in her lungs or chest cavity. So it was very, very brutal, very personal, and but we are going to continue watching Toby's outbursts. It started with opening arguments. He had outbursts before opening arguments even started. Every day he's had some kind of outburst. Yesterday, day 3, he wanted to go over Exhibit 68. There was another time at the end of the day, he was talking to his lawyer, and the lawyer turns around at the camera and says, I don't consent to recording. And the judge is like, well, we're not off the record yet, so, you know. So anyway, yeah, every day there's something going on with Mr. Madden. All right, so who is with us? We have got Aussie Gardner. Hello, welcome in. Good vibes only. Great to see you. Hey, William. Hello. Horse Welfare. Christine Fortunato. Good to see you. Kimbers. Happy hump day to you. Tammy and KS. Great to see you. Kaylee. Hello. Hell Rider. Good morning to you. Hope everyone's doing well. Hey, Iowa Backyard Cam, happy birthday to your daughter. Hope that she has a wonderful day today. Brenda, good morning to you. Camilla, great to see you. Thank you for joining us. We've got Kathy, Green Eyed Cat, saying good morning to everybody. Let's see. Excuse me. Let me see here. Let me scroll up to when we actually went live. Bing and Billy, good morning to you. All right, let's see. Grizzly Grandma Courtroom Addict, good morning. Welcome in. Heidi, how are you doing? So good to see you. Yeah, what's up? Hell Rider. Let's see. Just a Girl Baking popping in to say good morning. I hope you have a great day as well. Hey, Snap, how are you? Brett, good morning. Great to see you. Shirley Roth, how are you from your hospital bed? I hope you are doing well today. Christine, good morning. Good morning. Welcome in. Cindy Davidson waving at everybody, saying hello, hello. Amy Bella, good morning to you. Thank you for joining us. Snake Lady Dot. Henrietta, good morning. Listening from work again. It's the best way to do it. All right, let's take a moment and hit the like button. If you guys have not already, please hit the like button on your way in. Hot damn Elaine, good morning to you. All right, let's see. I think I got everybody. Let me see. Miss Chris MC, good morning to you. Welcome in. Hey, Sherry. How are you doing? Hoping Shirley's surgery went well. All right. I am doing well. Thank you, Hellrider. Hope you're doing just as well as we are. We didn't have rain yesterday, which was amazing. Paula, good morning. You missed all day yesterday, but caught up last night by watching at 1.5 speed. This is one wild and crazy trial. It absolutely is. Texas Law Cat, how are you? RX4, hey, how are you doing? Welcome in. Rev Ben, great to see you. Good morning. Ruth Wally, good morning. Happy hump day to you. Lazy Boys, great to see you. Just to Go Baking, he's a weepy kind of guy. Yeah, he does seem to sob a lot. Well, he sobs when he sees the autopsy photos, which I would think so because it's pretty brutal. Yeah, whenever you hear something that sounds like somebody crying, it's him. Sometimes they show him, sometimes they don't. They haven't been showing him recently, so. All right, so let's get started. And so we're on to day 4. All right, so day 4. Oh, and yesterday he came in and he does one of these like 4, and he's like pointing. It's like he hadn't had a shower or shaved in 4 days. So just imagine the smell that's emanating from him. I mean, I don't mean to laugh, but that's just wrong. And I think it's usually every other day, every 2 days they shower. Every other day, yeah, every other day. That's normal. Every other day they get a shower. So he hasn't been able to shower in, 4 days. RX for you. Happy hump day to you. All right. Hellrider, hopefully we don't have to worry about that command anymore. Hopefully we'd not have to worry about the Comcast command anymore. Now that they've replaced the nodes, and yeah, we haven't had problems. So it seems like they fixed it. So imagine that. All right, let's get started. Day 4. Day 4. Sorry. Day 4. All right, so here we go. Day 4. So he definitely has something around his middle section, right? Like you can kind of see across his back. He's got like a shock, I'm going to say shock belt, I guess, whatever those are called. Wait a minute. Ugh, I hate when they do that. They're playing the same thing over again. We just saw that. Why do they do that? They literally just, this video, they've done that before where they play the same thing over. Anyway, we just saw that. No, there's no audio. I wish because they're not on the record yet. Does anybody read lips? What's he saying? I assume he's talking to the judge. Who's he talking to? Nope, there's no judge there. So it must be the bailiff. He must be talking. Crunchy Frog. Well, the front part might be beer belly. The back, if you look at his back, he's got like you can see like two coils going across his back. All right, so let's we can fast forward a little bit here. And when the judge comes out. So I guess he was talking to the bailiff. All right, here comes the judge. Here comes the judge. Let me fast forward to the... Here she comes. All right, here we go. Judge is on the bench.
You're on the record on State versus Madden, CR 22-12-1675. The jurors are not present. The defendant is present with counsel, Mr. Wilder, and Mr. Burris, Mr. Hahn, and Detective Portman are present on behalf of the state of Ohio. Before the jurors come in, is there anything to put on the record on behalf of the state?
There is not anything. I just need, if I can, I was going through the exhibits real quick.
Oh, sure. Okay.
Nothing on behalf of the state of Ohio.
Anything on your behalf, Mr. Wilder?
Not at this time.
Okay.
You just give me one.
Sure. So witness here?
I guess you're right. Yeah. You want to be in the stand?
That's good. I can do that.
Okay.
I haven't read it. Screen down.
Just go ahead and proceed it for the time being.
Let's ask.
Good morning, ladies and gentlemen. I want to thank you again for coming in early today. Does anyone have any violations of the court's recess instructions that they need to report? Okay. All right. As you'll recall, we left in the middle of Detective Trenum's testimony. And Detective, I would remind you that you are still under oath. And Mr. Burris, you may resume your examination.
Yes, Your Honor. Thank you. Good morning again, sir.
Good morning, sir.
All right, I think the last thing that we left with was, I think I was getting ready to have you identify a couple of swabs.
Yes, sir.
So if I may approach the witness, Your Honor.
You may.
Yes, sir. I'm going to show you what has been marked as State's Exhibits 232 and 233. We'll start with 232 first. Can you tell us what State's Exhibit 232 is?
State's Exhibit 232 are swabs that I obtained from the green-colored vest jacket from the marker number 1 in the photographs from the lower left region of the red stain on the clothing.
With this court's permission, I'd ask to publish State's Exhibit 114. It's already been admitted.
Permission is granted.
Which is this on the two screen thing? Right, yeah.
You can block that, Mr. Malcolm. I'll get this fixed. That's probably it.
It's because it's on the screen. Go to the left. You want this in the slideshow?
It's not showing the one on the screen.
All right, on State's Exhibit 114, Detective, can you show us where you took the swab that is contained in State's Exhibit 232?
This region here, and that's where I obtained the swabs from the red stain on that clothing item.
Okay. And then, with the court's permission, I'd ask you to go ahead and open State's Exhibit 232.
Permission is granted.
Okay.
All right, and what is what you're holding in State's Exhibit 232?
Again, these are sterile cotton swabs that are prepackaged and sealed. Upon swabbing the red staining, I broke the seal, applied 2 drops of distilled water to each cotton swab, swabbed the red staining, put it back in this container, and then put it in an envelope to be sent off and examined by BCI.
Okay. And then State's Exhibit 233. What is State's Exhibit 233?
State's Exhibit 233 is the same swabs as 232, but from a different area. It's from marker number 2, the red staining above the tear within the fabric of the same article of clothing.
And with the court's permission, I'd ask you to open State's Exhibit 233.
Permission is granted.
And 233, again, prepackaged sterile tip cotton swabs. I swabbed the red staining in this area, identified on this article of clothing as number 2 in the same manner as number 1. Distilled water on the cotton swabs, swab the red staining, put back into its prepackage, put in this envelope, and then sent off to BCI for further analysis.
And if you would, Detective, I know you testified a little bit about this yesterday, but if you could refresh some of the recollections of the jurors. What sort of training have you undergone in order to take swabs like this from items of evidence that you've just described?
So I've actually taken an online training that was presented by the Ohio Attorney General's Office and by BCI with their clear instructions of how to properly collect and swab samples such as these according to the policies and procedures. So I'm following the policies and procedures that BCI would employ at their crime lab, but I'm doing it so with the instruction from them, from the training I received here in-house at our headquarters.
Okay. And then, if I can approach the witness.
You may.
Release the area of the witness. So you said you took a swab from this area right here.
Yes, sir.
Okay. And then the other one is from this area right here.
Yes, sir.
Is there a particular reason, or why did you pick those two areas?
I had actually collected swabs from all 5 identifiers on the front of the clothing, and I had taken the sterile scraping of the dry substance on the back of the clothing. When coordinating with BCI about what they felt was best to initially submit, they wanted me to just submit the swabs from identifier number 1 as State's Exhibit 232 and swabs from identifier number 2, State's Exhibit 233, along with submitting the entire article of clothing. So that was their recommendation.
Okay, so it wasn't necessarily your decision. It was sort of a collective effort of many individuals in order to determine which swabs to send up there?
Yes, sir.
Okay. And then when swabs are taken from items of evidence, like we see in State's Exhibit 114, what do you do with the swabs?
I package them sterilely and submit them online through a portal to BCI, and
Okay.
it is transported up to BCI.
I would assume that, I'm sorry, I cut you off, right?
It's hand delivered.
Okay. And I assume once those items are taken, once those swabs are taken from the item it's contained in State's Exhibit 114, I assume those swabs are kept at the Hamilton Police Department, like in a property room?
Yes, sir, they are.
Okay. And again, that property room is secure. Only certain people would have access to the property room?
Yes, sir. I don't even have access to the property room, so I turn it over to another individual who securely has access.
And then the items would be taken to BCI by, I believe it's a rotation of different detectives. A detective each week would take any items up to BCI that need to be taken?
Yes, it is hand delivered by one of us to maintain that chain of custody.
Okay. And with the court's permission, if I can display State's Exhibit 132. I think it's already been admitted.
No, permission is granted.
All right, so what are we looking at here in State's Exhibit 132, Detective?
After I collected swabs from each of the identifiers on the clothing, I then applied Blue Star in the same manner as I did in the sink in the bathroom at 1270 Parish Avenue to this article of clothing. Again, it appeared to me that the red staining on the article of clothing resembled that of blood. I applied Blue Star to see if I would get the same reaction as I would have in the sink and get the same chemiluminescent reaction as an indication for the potential presence or likelihood of blood being present. And when I applied Blue Star to identifier number 1 here, that was the reaction that I received, that there was a high likelihood that the red staining on the article of clothing was blood. I also applied it to be able to show the contrast between the stain and the color of the green jacket. It was kind of hard to see in its natural state. So this highlights the difference in location of where I obtained the swabs as well.
Okay. And you would have taken the swabs first?
Correct.
And then applied the Blue Star?
Yes.
Okay. State's Exhibit 133. What are we looking at here, Detective?
It is the same application of Blue Star, but it is on identifier number 2. I apologize, you can't see the identifier number 2 as clearly as number 1, but that is because the clothing item had folded when I was spraying it. But again, this is where I took swabs prior to the application of Blue Star and got the same reaction as I observed in number 1.
134.
This is identifier number 3 on the same clothing item. Again, with the application of Blue Star, I received the same chemiluminescent reaction, indicating that there was a high likelihood of blood being present from the area of where I obtained the swabs.
And then 135.
Identifier number 4. Again, same reaction of Blue Star from the area where I collected the swabs from this particular location on the same clothing item.
And then 136.
Number 5, again, collected swabs from this general area, administered Blue Star afterwards. We've seen the same reaction for the high likelihood of the presence of blood.
And then 137.
137 is the rear of the clothing item behind the left armpit. This was not a swab. Again, number 6 was a red stain, a substance that had dried and flaked. And so I took a sterile scalpel. Again, it's prepackaged like you would the cotton swabs. And I was able to scrape that off into a druggist fold paper, package that into an envelope, much like the ones for State's Exhibit 232 and 233. Once that was collected, I still applied Blue Star, got the same chemiluminescent reaction for the high likelihood that blood was present.
If I may approach the Chair.
You may.
And Detective, what I would ask the court's permission, and I believe you've already identified State's Exhibit 211, but I'll have you take out 211, please. And I know some of the tags have fallen off.
Yes.
So with the court's permission, if I can have the detective step down, and I would ask him to point on the actual exhibit itself where region number 1, 2, 3, 4, 5, and 6 are.
Permission is granted.
So again, a lot of the identifiers have fallen off because I manipulated it, BCI has manipulated it, they've done their own analysis, it got sent back to us, we did another reanalysis of some areas. Stage 1, still present in the lower left region of this general location. 2, again, the general location of the cut mark. 3, as you can see, is still attached. It is right here on the chest pocket with the zipper. 4 is over here, lower right region. 5 was upper right region. And then if you flip around to 6, on the rear, the left armpit, right here where I'm indicating with my index finger, is where number 6 I covered from.
Thank you, Detective. May I approach the witness, Your Honor?
You may.
And Detective, I'll hand you what's marked as State's Exhibit 218. I guess if you would, Detective, can you tell us what is in State's Exhibit 218, the first bag I gave you?
Do you want me to remove it from the bag?
Yes, please.
Okay. State's Exhibit 218 is a dark colored gray button-up shirt. It was recovered on the second search warrant conducted on the residence. However, it was located during the first search warrant on the residence, but we did not know its interpretive value. We did not know it was evidence until the second search warrant on the residence where we recovered it.
Okay. And if you hold up State's Exhibit 218 with the court's permission.
Permission is granted.
It's a short sleeve, button-up Dickies gray shirt.
Thank you, Detective. And I'll probably be asking you to hold that here in a second. If I can direct you to the evidence, the exhibit book, I'm going to ask you to look at State's Exhibits 138 through 146.
Okay. Yeah. Okay.
And generally speaking, what are we looking at in State's Exhibits 138 through 146?
State's Exhibit 138 through 146 are photographs that I collected of the same shirt that I just showed before you, where I identified numerous evidence of red staining on this clothing item. I did not identify all because there were too many, but there were numerous where I was able to locate on this gray shirt.
All right, in State's Exhibit 138 through 146, are all those photos that you took?
Yes, they are.
Okay. Are those photos true, fair, and accurate as to your visual observations you were making of this gray shirt when you took the photos?
Yes, sir, they are.
Your Honor, I would ask that 138 through 146 be admitted and permission to publish.
Any objection?
No objection.
All right, they'll be admitted and they may be published.
All right, what are we looking at in State's Exhibit 138?
State's Exhibit 138 is the gray shirt. And you can see that's just a photograph of it in its natural state.
And I know that you and I talked about this before. I know when looking at the photo, the shirt kind of looks green, doesn't it?
It does, yes. And that could be because of the lighting that we have at the department.
Okay. But the picture that we're looking at in State's Exhibit 138 is in fact the shirt that is on the floor behind you, on the ground behind you, which is State's Exhibit 218.
Yes, sir, it is. It's the same shirt.
Okay, and I guess with the court's permission, if you'd like to stand up and show the different tags. So I know there's a tag up top and there's a tag towards the bottom of the shirt there.
Permission is granted.
You can see
If you'd like to stand in front of the shirt, please.
inside the collar at the bottom of the shirt with the same manufacturer identifiers.
Okay. And inside the collar there is also Dickies and...
There is
Let's say Dickies and Flex.
Dickies Flex.
Okay. Thank you, Detective.
Yes, sir.
I don't think the tag fell off there, did it? All right, State's Exhibit 139. What are we looking at here in State's Exhibit 139?
This is the same shirt, but just generally, these are the locations where I identified what appeared to be blood stains, or red stains, if you will, on the front of the shirt. It is not all of them. It is just what was most apparent.
All right. State's Exhibit 140.
It's a close-up photograph. Same. It's showing identifiers 1, 2, 3, 4, 5 on the right-hand side. Or sorry, that would be the right-hand side in the photo, but it's the left side of the shirt. And then 19, 20, and 21 on the right-hand side of the shirt, but it's the left-hand side when viewing photographs.
State's Exhibit 141.
This is the upper portion of the shirt with also the left sleeve. You can see number 5 there in the lower portion of the photograph connecting the two images. Again, it's just another picture of the different identifiers that I had marked on the shirt.
State's Exhibit 142.
And this is showing the right sleeve and the identifiers that I marked there that appear to resemble that of red staining or blood.
The right sleeve, but the left side of the
photograph. Yes, it is. Yeah, you have to flip it in your mind.
All right, 143.
So these are close-up photographs of certain markers that I identified, number 2, 3, and 5. You can see the red staining in more detail.
State's Exhibit 144.
And this is the right sleeve. Well, yes, the right sleeve, but in the photograph it looks like it's on the left side, where you have identifiers number 13 and 14 that were marked.
State's Exhibit 145.
This is the back of the shirt, as is in its natural state.
And 146.
And this is where I identified just generally 3 locations of where that red staining appeared to be. As you can see now from the back, the right sleeve is on the correct side of the screen, it's on the right side. And then the left side over there, identifier, this one would be on the left side on the shirt.
And if I may approach the witness, Your Honor.
You may.
I'm going to hand you what has been marked State's Exhibit 234 and 235. And what is State's Exhibit 234?
State's Exhibit 234 are swabs of the red staining that I collected from identifier number 3 on the front of this same shirt within the lower left edge.
And then State's Exhibit 235.
And 235 are blood swabs taken from identifier number 14, which was the right sleeve of the shirt on the front portion.
All right, so in State's Exhibit 140 that's on the screen behind you,
Yes, sir.
worded swab, which is contained in State's Exhibit 234. Where did that come from?
From this location, identifier number 3.
So left side of the shirt, but right side on the State's Exhibit.
Correct.
Okay. And then where did swab 235 come from?
235 is going to be in a different State's Exhibit photograph because it's on the right sleeve.
Which one you want? I'm sorry.
Probably 142, probably.
Yes. So State's Exhibit 142. I have 13 and 14 on the right sleeve, but 14 specifically was this location here. Swabs of the red staining that are contained within State's Exhibit 235.
All right, and I assume that, or actually, again, explain to ladies and gentlemen of the jury here, what it is you did to take the swabs that are contained in States Exhibit 234 and 235. Explain how it is again that you did that.
Yes, so it's done in the same process as the swabs from the green vest. I collected them individually and separately. So States Exhibit 234 was collected, again, with prepackaged sterile cotton swabs, where distilled water was applied to the cotton swabs. I swabbed that area of staining, collecting it, putting it back in its prepackaged container, putting it in an envelope to send to BCI, and 235 was collected in the same manner, but from a different and separate region. It was collected from number 14 on the shirt.
And I assume that this would have been done at a different time than the jacket to make sure that there was no cross-contamination that was done.
Yes, absolutely. I believe everything was collected and swabbed on the same day. However, the jacket was swabbed and collected first, repackaged, I changed PPE, I reapplied PPE, gloves, and then handled the shirt separately away from the green vest. So there was no cross-contamination issue.
And what is PPE?
Personal protection equipment, gloves, goggles, masks.
Okay. And then with the court's permission, I'd ask the detective to be allowed to step down with States Exhibit 218, and I'd ask him to demonstrate on the actual exhibit, since probably several of the flags have fallen off, on the actual exhibit itself, where States Exhibit 234, where that swab came from, and States Exhibit 235.
Permission is granted.
So some of the stickers that are in place on the shirt have been moved, so the stickers that you can see, don't think that that's where they are. Whatever's in the photograph, that's where they are. These things get bounced around, as you can see once it's out. So States Exhibit 234, very faint, but you can see here, as it wraps around the left side of the shirt, which would be kind of the side where you have the seam. That's where that swab was collected for that States Exhibit. And on the front here, number 14 was right here on the right sleeve of the shirt. And differentiate, different. Number 13 was up here, but number 14 was back here, of course, the confidence.
Thank you, detective. And again, how was it decided that those would be the two swabs, swab 234, or swab that's in States Exhibit 234 and the swab contained in States Exhibit 235? How was that decision arrived at to send or to swab those areas and or to send that up to the lab?
Again, I spoke with the analysts and scientists at BCI. I gave them the pictures and documentation of this shirt, and it was their determination that
Okay. Sustained.
In consultation with BCI, is that why it is that you sent up those particular swabs?
Yes, sir, it is.
All right. I think you have the book. You have the books in front of you. If you would please flip to States Exhibits 158 through 166.
Okay.
And generally speaking, what is it that we're looking at in States Exhibits 158 through 166?
So these series of States exhibits were conducted after BCI had performed their analysis. Okay. And there's a particular reason why I say that, and we'll get to that. But these are photographs that I collected of the green vest here in States Exhibit 158, which we will more closely view the tear in the green vest jacket.
Right, so generally speaking, these are, again, photos of the green vest jacket?
Yes.
Okay. Are those photos that you took
Yes, they are.
true, fair, and accurate depictions of what it is that you were looking at when these photographs were taken?
Yes, sir.
Okay. Your Honor, I'd ask that 158 through 166 be admitted and permission to publish.
Any objection?
No objection.
Okay, they'll be admitted and they may be published.
All right. And Detective, what is it that we're looking at here in State's Exhibit 158?
State's Exhibit 158 is the green vest jacket. It's just kind of like an overview of the tear next to identifier number 2.
If you would, so in these photographs, we're going to be looking at the tear that's in the vest, is that correct?
Yes, sir.
And if you wouldn't mind, go ahead and circle the tear it is that you're visually seeing in State's Exhibit 158. State's Exhibit 159.
So this is a close-up photograph of the tear. Now, in order to be able to take this photograph and represent it as best as I could as the fabric naturally lays and be able to see the uniqueness of that tear, I had to insert a piece of printer paper between the front and the back of the clothing item so you could actually see what that tear looked like as it laid flat. Otherwise, it would blend in with the background of the vest through the tear. You wouldn't see it as well.
And these photographs were taken well after these items were sent off to the lab for testing and they were brought back to the Hamilton Police Department?
Yes, after the department and the prosecutor's office had spoke, we had decided that there was no more analysis to be performed by BCI and that we were given permission to handle said items in this manner.
State's Exhibit 160.
So, State's Exhibit 160.
And let me stop you there, Detective, if I may approach the witness.
You may.
Yes.
I believe we looked at this yesterday, but State's Exhibit 215. Again, what is State's Exhibit 215?
State's Exhibit 215 is the Swiss Army knife or multi-tool knife that was recovered from the residence.
Okay. And what is it that we're looking at in State's Exhibit 160 then?
I was asked to see if there was any correlation between the first blade attachment, where the blade was broken in some manner, and see if it correlated in any way or resembled in any way the tear that was observed on the green vest jacket.
Okay. And that's why it is you took this particular photograph?
Correct.
Okay. State's Exhibit 161.
Again, this is just another angle of how this uniqueness of the defect of the blade could have some similarities within the tear within that clothing.
162.
So again, with permission to handle these items in this manner, I inserted the knife between the front of the green vest jacket and the rear to be able to show maybe how the uniqueness of the blade defect could have caused this tear in this jacket, and is lined up as so.
State's Exhibit 163.
That is the orientation in which I took the photograph as observed in State's Exhibit 162, the one you just saw before. So that's how it was oriented and aligned as best as possible.
State's Exhibit 164.
So, State's Exhibit 164, again, with permission to handle said items of evidence, we aligned the gray shirt inside of the green vest as one would normally wear it to see if there were any correlations as to how it was aligned on someone's body if being worn together.
State's Exhibit 165.
And as you can see, I have then aligned the blade again to kind of demonstrate that uniqueness of the tear in the green vest jacket with the gray shirt inserted between.
And then 166.
And as an overall view of all the items combined with the blade itself having been inserted between the clothing items to kind of show the edge of the blade as having cut through the green vest.
All right, thank you, Detective. And then you have the exhibit book in front of you. I'd ask you to look at State's Exhibits 167 through 176.
Okay.
And generally speaking, what are we looking at in State's Exhibits 167 through 176?
These are photographs of the deceased victim's shirt where multiple tears were observed. And again, I was asked to see if there were any similarities with the multi-tool and specifically with the first blade attachment with the defected blade to see if anything lined up.
Again, are those photographs that you took
Yes, they are.
true, fair, and accurate depictions of what it is that you were looking at?
Yes, sir.
Your Honor, I'd ask the 167 through 176 be admitted and permission to publish.
Any objection?
No objection.
Okay, all right, they'll be admitted and they may be published.
If I may approach the witness.
You may.
All right, what are we looking at here in State's Exhibit? This has already been admitted 210.
State's Exhibit 210 is the deceased victim's shirt.
Okay.
As observed in the photograph above.
All right. So then what are we looking at in State's Exhibit 167?
That is the victim's shirt laid out flat as best as possible. It's the front of it.
State's Exhibit 168.
State's Exhibit 168 is a tear within the victim's shirt. Again, I was asked to see if there were any similarities between any of the tears in the victim's shirt with that unique first blade attachment of the multi-tool or Swiss Army knife.
State's Exhibit 169.
So that is a close-up view of one of the tears. I identified it as tear number 1 in the photograph, as State's Exhibit 168 depicted. This is a close-up photograph of this.
State's Exhibit 170.
This is with that multi-tool, and the first blade attachment has the piece that's missing from the blade aligned with the tear in this fabric.
State's Exhibit 171.
This is a second tear. I identified as tear number 2 within the victim's shirt.
All right, and if I can approach the
You may.
If you're able to, Detective, State's Exhibit 210, can you show us on the actual shirt itself, State's Exhibit 210, where that photograph is taken of?
Yes.
And with the court's permission, I ask the detective to be able to step down and show the jury.
Permission is granted.
Front of the victim's shirt.
If you need help, let me know.
And I took that photograph from this tear right here that I'm identifying. As you can see my thumb, that specific one is number 2.
Is that the bottom left part of the shirt?
It is. It is.
You can go and step down to make sure all the jurors are able to see that.
Again, I had to insert a piece of printer paper in the front and the back of the shirt so you can better visualize the layout of the tear when that's laid flat.
And State's Exhibit 172.
It's a close-up photograph of the tear identified as number 2 in the previous exhibit.
State's Exhibit 173.
And this is how it was aligned when that first blade attachment with the piece missing in the multi-tool appeared.
State's Exhibit 174.
This is tear number 4. That's on the victim's shirt.
And with the court's permission, Detective, are you able to show on the shirt where Exhibit number 4, the arrow is on the shirt?
Give me a minute, I have to look through them all.
And if you're not too sure, that's okay.
Yeah, I don't want to take up too much of the court's time. It is fairly difficult to relocate. Oh, no, I have located it. Identifier number 4 is actually a tear, which would be on the left side of the victim's shirt. You can see right here, I'm pointing with my thumb. So it's not necessarily on the front of the shirt. It's more towards the left side, like oblique to the waist would be. Again, to view it as best as possible, insert a piece of brown paper so you can see it in contrast with the background color of the center.
Thank you, Detective. State's Exhibit 175.
Again, this is the tear identified as number 4 in the previous exhibit, but with the same blade attachment, kind of aligned above the tear in the fabric.
And Exhibit 1,
And the same tear identified as number 4, but with the blade attachment not aligned above, but over top of the tear in the fabric.
all right, thank you, Detective. And if I may approach the witness, Shulman.
You may.
Go ahead, I think we're done with this stage. I think I neglected to ask you, going back to State's Exhibit 234 and 235, I believe you identified those as swabs that you took from the gray shirt. With the court's permission, if I can ask you to first open State's Exhibit 234.
Permission is granted.
.234, State's Exhibit, again, prepackaged sterile swabs, cotton swabs, that were taken from region number 3 of the gray shirt. Okay, so that was kind of like the lower left portion of the gray shirt. Again, I applied a couple drops of distilled water to each swab, rubbed the red staining, put the cotton swabs back in its original packaging, and prepackaged it in an envelope to be sent to BCI.
And then State's Exhibit 235, with the court's permission, I ask you to open 235.
Permission is granted.
And State's Exhibit 235. Same process of collection of the red staining as State's Exhibit 234. Prepackaged cotton swabs, distilled water applied to each swab, collected from the red staining of region number 14, which would have been the portion of the right sleeve on the front near the cuff. That was then put back in its original packaging, put into an envelope, and sent to BCI.
And likewise with the other 2 swabs, 232 and 233, those would have been kept at the Hamilton Police Department in property room.
Yes, sir.
And again, only certain people would have access to that property.
Yes, sir.
And would have been taken up to BCI for testing.
Yes, sir.
Okay. And I think the ladies and gentlemen of the jury have heard a little bit about this, but Detective, were you assigned to a breaking, entering / burglary type offense that allegedly occurred at 1270 Parish Avenue on, I believe the date would have been October 6th of 2022?
Yes, I was.
Okay. Tell us how it is that you were assigned that particular case.
The defendant, Toby Madden, had made a offense report to Officer Bryant that I had been assigned for follow-up.
And what do you mean by follow-up?
I was assigned to reach out to Mr. Madden to kind of identify if there were any alleged suspects involved with the breaking and entering of the residence at 1270 Parish Avenue.
Okay. And what methods did you use or how did you attempt to make contact with Toby Madden as a follow-up?
Yes, so on the offense report that P.O. Bryant had filed, he had gathered...
Objection, can we have a sidebar?
Yes.
All right, while they're at this sidebar, I'm trying to struggle. Why did this vest and shirt... Sorry. Why did this vest and shirt... Why was it cut up? Why did it have stains on it? He had no marks on him. Remember, there was photos of him without a shirt on? He just had, like, some scratches here. He had no like puncture wounds. I'm trying to figure out why did this vest have vest and shirt combo? I'm really racking my brain about that. Green-eyed cat. Could Toby have done it to himself on purpose, trying to make it look like it was self-defense? But he doesn't have any marks on him. Unless he did it. Okay, so he just did it to the shirt and the vest, but not actually to himself. Do you think he did it on purpose? Could he have had the vest on undershirt to protect himself? Well, the way they just explained it, the shirt, or the vest and then the shirt, and they were...
I believe my question was, what methods or how did you try to make contact with Toby Madden?
So using the information from the report, phone number, address, I attempted to make contact by calling the listed phone number on the offense report to speak with Mr. Madden. I received no answer after calling twice. I then left my business card with my name, identifying that I was a detective with the City of Hamilton Police Department at the residence
Of 1270 Parish?
of 1270 Parish. The report, though, indicated an incorrect address for Mr. Madden. Said he resided at 250 Brookwood Avenue, which is not a good address for the defendant. The offense report was made for 1270 Parish Avenue. That's where I had responded to in an attempt to speak with Mr. Madden and leaving my card. After having left my card, I still never received a call or a contact from Mr. Madden himself, and I made the case inactive until he made attempts to reach out to me.
If I can have probably 2 or 3 moments, Your Honor.
Yes, sir.
Give me 1 second, Mr. Weller.
All right, I'm answering Brat and Green-Eyed Cat. You guys, those are great theories that he, did those cuts by himself. Self-defense. But he doesn't tell law enforcement, I was attacked and I was fighting off and all this stuff. So he doesn't tell law enforcement that. So that doesn't fit his story. So that's why it's just more confusing. I mean, and that's very plausible that, he says he woke up and he saw these attackers and he fought them off, but he doesn't say that. He just says he woke up and he found Rachelle, expired. Hey, Gordon. Welcome in. I don't know. Maybe the state will wrap it up in closings or something. I'm not quite understanding it right now.
I believe that's all the questions I had, Your Honor. Thank you.
Thank you. Cross-examination.
Good morning, Detective.
Good morning, sir.
I want to talk to you with this, the alleged burglary incident you just spoke of. Is there a chance you didn't have the correct number when trying to contact Mr. Madden?
To be honest with you, whatever number I was given was the one I attempted to make contact with. I received no contact. That's why I made a personal appearance to drop my card in case the number was wrong.
Okay.
He could contact me with the correct number.
Sure. But my original question is there a chance you had the wrong number?
Yes, the phone number could have been documented incorrectly by the reporting officer.
And the reporting officer on that was Taylor Bryant, correct?
Yes, sir.
And did you review his report before you came into court today?
Yes, I've reviewed that report.
And were you, at the time, were you a detective assigned to that specific burglary that occurred 5 days before?
Yes, I was.
Is it your understanding that Officer Bryant responded to the scene
Yes, he did.
and took photos.
Yes, sir.
And does his report indicate that there was damage to the back door?
Yes, it does.
Did you have any contact with anybody else at 1270 Parish, such as Rachelle?
No, I did not.
And you never spoke or saw Mr. Madden in relation to the burglary 5 days before?
No, sir.
Did you yourself go out to 1270 Parish and look at the property or the door at all?
I didn't. No, I don't. I try to make contact with residents there before going to the back of the residence, make my appearance known that, hey, I'm law enforcement. I'm not somebody just wandering about in your backyard. So I did not go to the rear of the residence and inspect the damage as reported.
Okay.
I just went to the residence to try and make contact with a homeowner or a resident there.
Sure. And Detective, you can't do every single thing possible on a case. Sometimes you have to rely on reporting officers or patrolmen to do certain things for you and give you this evidence for you to follow up on if you need to. Is that kind of fair?
Yes, sir.
Okay. I want to start with regards to the incident that ends up happening 5 days later. The knife, if the state wouldn't mind, since they're connected to the overhead, if you could put 150 up for me, please. Yeah. Detective, where did this knife come from within the parish residence?
It was located within the deceased victim's black backpack.
To your knowledge, was that black backpack, was it zipped up or buttoned up in any way?
I can't recall if it was zipped up or secured in any way.
Okay. Now, you testified that you observed this knife and you thought that there may be some sort of residue or some sort of wiping on this. Is that what you testified to?
Yes.
Now, you've shown us the fluorescent blue star that you used on other things, the sink, we saw it on the vest. Why did you never use the blue star on this knife to see if there was presence for blood on this?
That's because, again, this was a critical piece of evidence. So you kind of have to weigh the results of some tests being performed versus what your results may be. Knowing that this was a critical piece of evidence that might have minimal but sufficient important evidence to this case, I did not want to interrupt any DNA typing or analysis conducted by BCI by introducing Blue Star. Blue Star is a tool, it's a screening tool that you can use if you have sufficient evidence to use it. Here, I did not want to use it on such a critical piece of item of evidence. I just wanted to document it and submit it to the lab so they could do their own analysis in a more sterile environment.
I thought you testified, though, about Blue Star that doesn't interrupt blood presence if it's there. I thought you said that to us.
Yes, you are right. It does not interrupt DNA typing or analysis. But again, you want to be able to have sufficient evidence to document the presence of blood. And on such a small knife blade, I don't want to apply Blue Star by overspraying and causing any DNA or blood that could have been present to fall off of the blade onto the sterile cardboard sheet below, and therefore losing that value of any evidence or potential evidence.
Okay. And the determination and maybe the conclusion of whether or not this blade has blood on it, that's for a DNA expert from BCI. Is that fair?
Yes, sir.
Were there any photos of this knife sent to the coroner?
If there were, I did not send them. I do not know.
Okay. That wasn't something you were involved with?
No, sir.
Do you recall? Well, you weren't recorded. The coroner referenced maybe possibly having a photo of a knife, but you're saying you weren't involved with that?
No, sir, I was not.
Did you attend the autopsy?
No, I did not.
Is it a common practice for someone within your department or your agency to attend the autopsy?
That depends upon the coroner. I guess it's a case by case Sometimes we're allowed to attend, and sometimes we're not allowed to attend. But I did not attend.
To your knowledge, within the residence during these searches, were there any rags, towels, paper towels covered in blood recovered?
Not that were apparent or observed at the scene.
If the state could please pull up 77. Detective, this is one of the exhibits that you testified to, I believe it was yesterday. So the fluorescent that we're seeing here is indicating that there's blood that was present at some point. Is that fair?
Yes, it is a screening tool that gives you with a high degree of certainty that within the fluorescence that there is a high likelihood that blood is present.
Okay. And you would agree with me that a sink is normally a place where you're going to wash your hands, correct?
That is correct.
And would you agree with me that if you had placed your hands on someone's body to perhaps give CPR that you might end up with blood on your hands?
That is correct.
Are we able to tell from this fluorescent imaging whether someone washed their hands, but then they try to wipe any and everything away from the sink? Can we tell that from this image?
No, I don't see any apparent, if you're asking for like smears or wipes.
Because what I want to ask is if someone washed their hands in this sink and there's blood that falls in the sink, the water takes most of the blood down into the sink, but then someone wants to then take a rag, kind of wipe the bowl out, wipe the edges. Would this fluorescent that we see in State's Exhibit 77, would it appear differently? Would it have swirls and motions like that for the blood?
I don't know if it would or not, to be honest with you. I just know how to detect its presence and recognize its appearance with the reaction. I don't know if it would show a smear.
Okay. Well, during your training with Blue Star, do they not cover something like that we can not only detect where blood has dropped, but we can also tell if someone has tried to wipe blood away? Is that not part of the training?
No, I'm sure you could be able to indicate if something has been wiped up. But specifically, no, that was not covered in any of the trainings that I was a part of.
All right. So you're telling me this picture is going to appear that way, whether the blood just was washed off hands, went down the sink, or if someone sat there and you literally used a towel to try to wipe everything up. You can't tell us if this picture would be different if someone tried to wipe all that away?
Oh, no, I'm sure it has the possibility of appearing different, yes.
Just a possibility? You don't think it would show swirls in this picture if someone used a towel?
I haven't been a part of any type of practical examination of that.
Okay.
But it is possible, yes.
You were involved with some of the searches at the property, correct?
Yes, I was there.
Were you involved with the search of Rachelle's car at the residence?
I did not search the victim's car.
Okay, so you would not be aware that rifles were found inside her car?
I was not a part of that search.
If the state wouldn't mind putting Exhibit 160 up. I want to talk to you about State's Exhibit 160. You were talking about the knife, and you were talking about some of the cuts within the vest. You've handled not only the vest and the knife. You've seen pictures of it. You were there. You've analyzed it. Would you agree with me that the vest and the knife are not new?
Are not new.
Meaning like they don't appear that they were recently purchased. They appear old. It's not like they were 1 week old, like they've just been bought.
I can't date the appearance of clothing when it was purchased versus if it's worn, and same thing with a knife.
All right, well, You can't tell does that knife appear to be new?
No, it doesn't appear to be brand new, but I'm not going to date it.
Does that appear to be rust on the knife?
Yeah, there could be indications of rust on the knife.
I mean, common knowledge, rust doesn't appear just overnight, right?
Right.
Takes a long time.
I don't. Again.
Just off your common everyday knowledge with the things you have in your house or you've been around, it takes a long time for rust to set in. Is that fair?
I would say it does take time for rust to set in.
Okay.
Yes.
When you're testifying about the cut in this vest, you said you had to put a piece of white paper underneath it to see it, correct?
Yes, because the background behind the cut is the same as the foreground, so it blends in. So yeah, I had to put a piece of paper in between so you can see the actual layout of the tear in the fabric.
So this, in order to find this cut and to look at it, you had to get pretty close to it. Is that fair?
Yes.
So if there was an angle from a Kroger video up on a ceiling, there's a chance it might not capture a cut that's in a vest. Is that fair?
That depends on the quality of the camera.
Well, true, but you do agree with me that you need a piece of copy paper just to see the cut up close, right?
I think it highlights the difference. It contrasts it. You can see the cut. I could pull the article item out, and the jury and everybody here would see the location of where the cut is. But to see it more thoroughly as what its design is, you need to highlight and contrast the differences between the front of the vest and the back of the vest. So,
and we don't know how long that cut's been on that vest. Is that fair?
I don't have any way to date how long that cut's been there.
All right, that's all. Well, give me 1 second to confirm. Nothing further, Judge.
Okay, thank you. Any redirect?
Hold on.
Oh, okay.
I'll stand here if that's all right.
Sure.
Sir, did you do any kind of blue star illumination on the back door or near the back door?
No, I did not.
Was there any thing you did to try to observe or find out if there was any blood or other evidence at the back door?
The back door was locked with both doorknobs. I didn't have an indication that it had been opened at the time that I responded for the first search warrant on the day of the incident. So no, I did not.
But you were aware that 5 days before a burglary had been reported at that back door?
Yes.
Okay. Nothing further.
Thank you. Redirect?
Again, it was just reported. There was no follow-up that was able to be done because you couldn't make contact with him.
That is correct.
Thank you, Judge.
Okay. Thank you, Detective. You may
Thank you,
step
Your Honor.
down. State ready to call its next witness.
First of all, I believe Detective Trennan can be released from the state subpoena, although Mr. Wilder would like him.
I'm sorry, Judge.
Detective Trennan would be recalled.
No.
Okay, I just want to release him from my subpoena. All right. John, this might be a good, I know it's a little early, this might be a good mid-morning break time because I think the next witness is going to be very late.
Okay. All right. Well, then let's go ahead. Thank you for that. Let's go ahead and take our break. It's about 9:40. We'll take 15 minutes and come back at 9:55. Please remember my recess instructions. Okay, the jurors have been excused from the courtroom. Before we take recess, I did give out jury instructions on Monday. As we're getting further along in the case, I'd like counsel to be prepared to have our first discussion about those at the conclusion of the state's case. I anticipate we'll have additional conversations, but just to get a start on that after we've at least heard the state's case. Other than that, is there anything from the state before we take our break?
I anticipate two more witnesses, Catherine Daly from BCI and Tanya Cook.
Thank you for that. Mr. Wilder?
Judge, are we still on the path of stopping at 12 like yesterday? Is that still
Yes, sir.
Today?
Yes, sir.
And that includes anything, even with instructions or other thing, we're dropping at 12?
Pretty close to. If we need just a few minutes, I can spare that, but any lengthy discussions we'll have to have about tomorrow.
Okay.
And to be, hold on, nothing else, Sean.
Okay, all right. We'll be back then at 9:55. Thank you.
Yeah, I don't know who he keeps looking at. Maybe Michaela, because she's in the gallery. He thanked somebody. Yesterday he said thank you. I think he waved to somebody, said thank you or something like that. And I'm not going to fast forward because you never know what he's going to say or do. If they go to the state seal, then I'll fast forward. But Treasure Hog, maybe he's trying to look at the camera. He knows where the camera is. He has looked at the camera multiple times. Welcome back, Sweet Vampy. All right, I would love to know whose blood was on that jacket and the vest. They said there was multiple red stains on both the vest and the jacket. I'm assuming it's Rachelle's. But then the jacket and vest were cut as well. This makes no sense. Because he had no wounds, no puncture wounds on him. He had some scratches and that was it. Now the detective did say he doesn't know when the let me just cue us up here. The detective,
First, Mr. Hahn and Detective.
The detective did say he doesn't know when the tears in the vest and shirt happen. But then there's blood on them. I don't understand. Well, I guess a DNA expert. I don't know if they call a DNA expert. Apparently they have two more witnesses and then they're going to rest, it sounds like. So maybe this next witness will be a DNA expert. I don't know. All right, here we go.
Mr. Burrs, Mr. Hahn, and Detective Horton are present, and Mr. Wilder is present with Mr. Madden, who appears in person. Before the jury comes in, is there anything on behalf of the state of Ohio?
Just the next witness, Catherine Daly, does not wish to be filmed. That way,
Very well. Anything else, Mr. Wilder?
Not at this time.
Okay. Please be seated. Are there any violations of the court's recess instructions that anyone needs to report? Okay.
Yes, Sean, thank you. The state of Ohio would call Catherine Daly.
You may proceed.
Yes, Your Honor, thank you. Good morning.
Good morning.
Appreciate you being here. Would you please state your name for the record and spell your first and last name?
Yes, my name is Catherine Daly. First name is spelled Katharine. Last name Daly, Dailey.
Okay. And where are you currently employed?
I'm currently employed at the Ohio Bureau of Criminal Investigations. It's commonly referred to as BCI.
Okay. And what is BCI?
BCI is a law enforcement agency that will assist various other local law enforcement agencies in the investigation of crimes.
Okay. And is there a particular section of BCI that you work for?
Yes, I work in the laboratory section, specifically in the DNA section.
Okay. And what would be your job title at BCI?
I'm a forensic scientist.
Okay. And explain to the ladies and gentlemen of the jury what it means to be a forensic scientist.
A forensic scientist will look at items of evidence and collect samples for different types of analyses. In my case, collect samples for DNA analysis.
Okay. And in regards to your employment at BCI, being a forensic scientist in the DNA, actually, are you assigned to the DNA section?
Yes.
Okay. So then in regards to your employment being a forensic scientist in the DNA section, would you please describe to the ladies and gentlemen of the jury your education, your background and training in order to achieve such a position?
Yes, I have a Bachelor of Science degree. My degree was from Ohio University in Athens, Ohio. My major was in microbiology and my minor was in chemistry. And upon being hired at BCI, I underwent a year-long training program that included mock cases, lectures, online coursework through West Virginia State University, reading of forensic articles, journal articles, and lots of other things as well.
Okay. And how long have you been assigned to the DNA section at BCI?
I started in December of 2011, so I'm coming up on 13 years.
And on prior occasions, have you had the opportunity to conduct testing for DNA on different evidentiary items that have been submitted to BCI?
Yes, I have.
Okay. Do you have any idea how many times you run such tests?
Thousands of times.
Okay. And based on the thousands of times that you have conducted these types of tests, have you been able to make either a positive identification or I guess not an identification based on the testing experience you have run on evidentiary items submitted to your lab?
Yes, I have.
Okay. And if I use the phrase inclusions, what does that mean to you?
If someone is determined to be included in a DNA profile, that means that their DNA profile that we obtain from a known standard is consistent with that of a DNA profile obtained from an evidence item.
Okay. And if I use the phrase exclusion, what would that mean?
That means when making those two comparisons again between the known DNA standard and a DNA profile from an evidence item, at least one of the locations that we're looking at on that DNA profile is not consistent.
Okay. And have you previously been qualified as an expert in forensic science in the courts of law, first of all, here in the state of Ohio?
Yes.
How many times would you say that you have been?
It's upwards of 80 times.
Okay. And how about outside of the state of Ohio or including the federal system? Have you been called to testify as an expert as well in either other states or in the federal system?
In the federal system, yes.
Okay. How many times would you say you testified in the federal system?
One time that I can recall offhand.
Okay. I believe you told me this here in the state of Ohio goes in the federal system?
Yes.
Okay. And, at this point, Your Honor, I would tender Ms. Daly as an expert in forensic science as it relates to DNA analysis.
Mr. Wilder?
Judge, no voir dire for this witness, no objection.
Very well. Witness will be so qualified.
Okay, thank you, Your Honor. Now, Ms. Daly, it's my understanding that you were asked to compare various items in the cases before this court in regards to DNA. Is that correct?
Yes, that's correct.
And as part of the comparison process that I'm going to have you talk about, generally speaking, can you educate the ladies and gentlemen of the jury as to how it is evidence arrives at your laboratory here at BCI?
Yes, a local law enforcement agency will bring the evidence to our laboratory, and our evidence receiving staff will take in that evidence. It's assigned a unique case number, and each item of evidence is given a unique item number. These are tracked throughout the laboratory via barcodes, and they are placed in a secure vault until analysis is to be done on those items of evidence.
Can you use it? I don't think I'll need the computer. And if I may approach the element,
You may.
and hopefully there'll be an item that's on the screen behind you. This is going to be, just for purposes, this is going to be State's Exhibit 234. And just generally speaking, there's a kind of a light purplish type label that is on this particular exhibit. Can you just explain what it is that we're looking at here? Because I know you started talking about barcodes and things like that. So what is indicated on this particular exhibit?
So this purple barcode that is on this item will tell us what the BCI lab number associated with this item of evidence in this case is. It also tells us what the BCI item number is. At the top it says item 15. It'll tell us what agency submitted that item as well as their agency case number. And this is the barcode that would be used to track that evidence item throughout the laboratory. So for instance, when I would take this item of evidence into my custody, I also have a barcode that's assigned to me. So this would track it in the computer system saying that it's in my custody.
Okay. And I would assume that each case would have a unique lab number, is that correct?
Yes, that's correct.
Okay, and then, but if there's multiple items that are submitted under the same lab number, that's how we get item number 1, 2, 3, 4, 5, all the way up to however many items PCI winds up getting?
That's correct.
Okay. And I would assume that when items are submitted to BCI, where would they be stored? Obviously prior to testing and then stored after testing.
They're secured in a evidence vault.
Okay. And again, I assume that not just anybody has access to the evidence vault. There's only certain people who will be allowed to go into the evidence vault.
Yes, it's limited access.
Okay. And I would assume that there has to be some sort of code punched in order to go into the vault to obtain items.
Yes, in order to obtain those items, you have to scan a card as well as punch in a specific number to the individual that's trying to get into the vault.
Okay. I'm going to take this down for now. So how is it that you're able to ensure the integrity of evidence that is submitted to BCI and stored at BCI prior to testing?
So when the evidence items are received by the laboratory, the seal is checked on those items of evidence, as well as when that item of evidence is retrieved for analysis, the seal is also checked and noted. If any irregularities would be noticed, that would be put in the analysis notes.
Okay, thank you. And I believe that I have used the phrase DNA, and I'm sure everybody has heard from TVs and movies about DNA, but could you please educate ladies and gentlemen of the jury here as to what DNA is and what does DNA stand for?
Yes, DNA stands for deoxyribonucleic acid. It is the blueprint for our bodies, so it's going to tell us things like what color hair we might have or what color eyes we might have. We get half of our DNA from our mom and half from our dad, and it's unique to each individual except for in the case of identical twins, and it's also the same throughout our body. So if I were to take a swab from my cheek and a blood sample for myself, the DNA profile developed from each of those would be the same.
Now, in regards to DNA and what it is we just testified about, can DNA be used for comparison purposes to see if you can identify samples left behind on different objects to a certain individual?
Yes, it can.
Okay, if you would explain, ladies and gentlemen, jury, how it is that you can do that.
So when we're making a DNA comparison, it's a 4-step process. The first step is going to be extraction. So we're going to take the DNA off of whatever item it was, whether it was a swab similar to a Q-tip, a cutting from an item, or a sample from like a cigarette butt. The second step that we're going to do then is quantification. We're going to determine how much DNA was obtained from that sample. Third step is called amplification, where we're going to make millions and millions of copies of certain regions of the DNA. And the fourth step is a real fancy word for taking a picture. It's called electrophoresis. So when I have those pictures at the end from both the evidence samples as well as the known reference standards, I can compare those two together and see if they are similar or dissimilar.
Okay. Now, in regards to DNA that may be left behind on a particular item, can you explain to ladies and gentlemen of the jury how that might happen?
Yes, DNA can be left behind on an item a number of different ways through bodily fluids, so saliva, urine, feces, semen, blood, or it could be left behind on an item by touching it. So my DNA would be expected to be on the binder that I brought with me today.
Okay. And if I use the phrase primary transfer, what does that mean to you?
That is the direct transfer of DNA to an item. So my DNA to my binder would be primary transfer.
Okay. And then what about secondary transfer?
Secondary transfer would be if someone came and picked up my binder other than myself. And if I were to try to swab their hands, they may or may not have my DNA on their hands because of that secondary transfer.
Now, in regards to internal lab protocols at BCI, what efforts are made to prevent cross-contamination or mixture of substances or samples that you may test?
So there are a number of different precautions that we take at the laboratory. Just to name a few, only one item of evidence is open at a time, so we're only looking at one item of evidence. We will also use a bleach solution to bleach down our worktops. We use brown paper to serve as a barrier between that bleached benchtop and the item of evidence. We also wear personal protective equipment, so gloves, masks, lab coats, just to name a few things.
So in essence, you're not going to be testing multiple items at a time, is that correct?
That's correct.
And I assume every time an item is tested, all surfaces and utensils will be cleaned before testing another sample?
Yes, absolutely.
And I assume that those are the protocols that BCI puts in place specifically for all employees to follow to make sure there isn't any sort of cross-contamination or anything like that?
Yes.
All right, so now in regards to DNA, what is the methodology that is used for determining if a particular item does have any DNA on it? And if it does, take us through the process, and I think you talked about it a little bit, of extracting that DNA from that item.
Yes. So initially the item is received by a forensic biologist, and the forensic biologist is someone that's going to look at the item of evidence and collect any relevant samples. So they're going to look at potential bodily fluids, see if they can perform any testing to try to help determine what that bodily fluid might be. They'll collect samples from either bodily fluids or samples where someone might come into contact with an item. So shirts may be the way they wore it, so they'll swab the shoulder areas that come into contact with your skin. If it's something like a cigarette butt, they might take a cutting from the paper around the cigarette butt, and those samples are then placed into a tube and they are sent forward for the DNA analysis process. The DNA analysis process is that 4-step process that I mentioned earlier.
And go ahead, just the different names of the process.
Yes. So first is extraction, Second is quantification, then amplification, and then electrophoresis, where we get a picture of the DNA profile at the end.
So what is it that you're actually doing to the sample that you have in order to extract the DNA?
We are applying certain chemicals to that sample to help remove the DNA off of whatever the substrate was that it was on, whether it was a swab or a piece of paper, and get it into the solution so that we can look at just the DNA itself.
All right, and we're going to get into this here probably very shortly, but with that process, with that process that you do with the items that they're going to be compared, there's probably two different phrases that we're going to talk about. So what is a known sample?
A known sample is a sample collected from an individual, so the origin is known. So we can use that DNA profile obtained from that item as a reference standard for comparison to any unknowns.
Okay. And then what's an unknown sample?
An unknown sample is a DNA profile that is obtained from evidence items within the case.
Okay. Like the items have been submitted to you guys?
Yes.
So then in regards to known samples that BCI would receive and unknown samples that BCI would receive, would you be able to compare those known samples to unknown samples to see if there is a match?
Yes.
And I assume when you make that type of comparison, whether they're known samples or unknown samples, do you generate or author a report to document what your findings are?
Yes.
And I assume that those reports are generated in the ordinary course of business by BCI?
Yes.
And those labs would be, or those lab reports would be kept in the ordinary course of business at BCI?
Yes.
And would you have done that in this particular case?
Yes, I did.
Okay. And when you compare DNA samples or unknown samples to known samples, are you able to calculate a statistical frequency of a particular DNA profile?
Yes, we will calculate statistics on the evidence profile to show how rare or how common it is within the population.
Okay. And if I may approach the witness, Your Honor.
You may.
Be 239 and 240. Ma'am, I'm handing you what's been marked as State's Exhibits 239 and 240. What are State's Exhibits 239 and 240?
These are copies of the reports that I authored in this case.
Okay. The true, fair, and accurate. Is that actually? Let me ask you this: is that a copy of your report?
Yes.
Okay. And is that a true, fair, and accurate copy of the report that you would have generated?
Yes, it is.
Okay. And would that aid you in your testimony today?
Yes.
Okay. I know we have several things to go through. All right. If I may approach the witness, Your Honor. I'll have you identify what State's Exhibit 222 is, please.
State's Exhibit 222 is BCI item number 1, which is a DNA standard from Ms. Brewsaugh.
And I think that is the only one that has not been opened. Can I borrow your scissors? Okay, put your
You may.
And what is contained within State's Exhibit 222?
State's Exhibit 222 has a blood card from Ms. Brewsaugh.
And if I could ask you to open that second envelope as well, then I'll take this from you. All right, so 222, if I can have it. Does that have a similar label that it is that you talked about before item number 1?
Yes, it does.
Okay, and we have the unique laboratory number 22-19832.
Correct.
I'll take that from you. And does this card that is inside, does that have any markings that you're familiar with or that you recognize?
Yes, it does.
Okay, what are the markings that you recognize?
The markings on this item have the BCI lab number, our item number, and the individual's initials and date of the individual who took the samples, as well as what date the samples were taken.
And then State's Exhibit 223.
State's Exhibit 223 is BCI item number 2, which is a DNA standard from Mr. Madden.
And if you would take out what's inside, and I will put the envelope, I did ask the court's permission before, I have permission to publish
Yes.
223.
Yes, granted.
And on the screen to your left, again, do you recognize any of the numbers or markings on that?
Yes, this is the barcode for BCI item number 2 under BCI case number 22-19832.
Right. And then what is contained within State's Exhibit 223?
There are 2 manila envelopes in here, and they have swabs within them.
Okay. I believe this particular one is open. Would you mind taking that out, please? Did you recognize, are there any markings on that particular exhibit that you recognize?
Yes, on this exhibit, there are the same markings as before from the analyst who took the sample from this item.
And permission to publish, Your Honor.
Permission is granted.
Is that what we're looking at here on the screen?
Yes, it is.
All right, so speaking now about State's Exhibit 222, the blood card for Ms. Brewsaugh, and 223, the swabs from Toby Madden. These would be what are known as known samples, is that correct?
That's correct.
Okay. And are these two items, the 222 and 223, are those items that would have been tested by BCI?
Yes.
Okay, and let's start with 222, the blood card from Ms. Brewsaugh. Were you able to develop a DNA profile from that blood stain card?
Yes, I was.
Okay. And would that DNA profile, would that have been developed using the procedures outlined up for the lady and gentleman here?
Yes.
Okay. And I guess if you would, now that we're talking about an actual sample, if you would, just go ahead and briefly explain to them the procedures again as to how you develop a DNA profile from that.
Yes. So in this instance, a tip of the swab would have been cut into a tube, and it would have been sent forward for the DNA analysis process. So it would have been undergone the extraction process, quantification, amplification, and electrophoresis. And then I would have used that picture of the DNA profile to make my comparisons to any profiles developed from evidence items.
And from State's Exhibit 222, the blood stain card, were you able to develop a DNA profile?
Yes, I was.
Okay. And if I use the wrong word, please correct me. And then in regards to State's Exhibit 223, the swab from individual identified as Toby Madden, were you able to develop a DNA profile from that particular item as well?
Yes.
And you would have used the same procedures that have now been outlined twice by you in order to generate a DNA profile?
That's correct.
Okay. And you were able to develop a DNA profile?
Yes.
Okay. So now that BCI has a DNA profile from Ms. Brewsaugh from the blood stain card, and now has a DNA profile from Toby Madden from the swab, are you now able to, I guess, compare those particular items, the blood stain from 222, the DNA profile, and the DNA profile from 223, are you able to compare that to unknown samples?
Yes.
Okay. And then by comparing those known samples to unknown samples, that's how you're able to either include or exclude.
That's correct.
Okay. And if I may approach the witness, Your Honor.
You may.
Now I'll hand you what's been marked as State's Exhibit 224. Can I have you identify what State's Exhibit 224 is?
State's Exhibit 224 is BCI item number 3, which is a envelope containing Ms. Brewsaugh's left hand fingernail clippings, as well as a fingernail clipper.
And if I may display State's Exhibit 224.
You may.
And again, do you recognize any of the labeling on State's Exhibit 224?
Yes, I recognize the BCI barcode as well as the individual's initials and date when they collected the sample from the item.
Okay. And much like the procedures that you use to develop a DNA profile from 222 and 223, would you have done something similar to State's Exhibit 224?
Yes.
Okay. And were you able to develop any sort of profiles on that?
Yes.
Okay, and then let me ask you this. Were you able to come to a reasonable degree of scientific certainty? Do you have an opinion as to the DNA profile that was found in State's Exhibit 224?
Yes.
Okay, what is that opinion?
It is a mixture of DNA profiles, so that means there's more than one individual contributing to the DNA on the left-hand fingernail clipping, specifically a swabbing from a stain. The major DNA profile, or the individuals that is contributing a higher concentration or a higher amount of DNA, that DNA profile is consistent with Ms. Brewsaugh. Mr. Madden is not that major contributor, and the additional DNA on that item is not of sufficient quality for any comparisons.
Okay. And is there a statistical analysis or a statistical breakdown as to the frequency of Ms. Brewsaugh?
Yes, the DNA profile, the major DNA profile from the fingernail clippings, specifically the swabbing from the stain, the estimated frequency of occurrence of the major DNA profile is rarer than 1 in 1 trillion unrelated individuals. So that means I would have to test a number larger than 1 trillion individuals to expect to find this DNA profile again in the population.
And certainly there's not a trillion people in this world, are there?
They are not.
What does it mean to be a major contributor, and obviously what does it mean to not be a major contributor?
A major contributor is an individual that's contributing a higher concentration or a higher amount of DNA in the sample compared to any other contributor or contributors.
State's Exhibit 225. Have you identified that, please, ma'am?
State's Exhibit 225 is BCI item number 4, which is a envelope that contains Ms. Brewsaugh's left-hand fingernail scrapings.
Okay. And what is the difference between, if you know, fingernail clippings versus fingernail scrapings?
My understanding is in the method of collection, a scraping is what it sounds like, scraping underneath someone's nails, versus a clipping is similar to how you or I would clip our nails.
And I'll go and put this up here. State's Exhibit 225. Has that been admitted, Your Honor, officially?
No, it's been identified but not admitted.
I guess I probably should have asked for 224 to be admitted to 225. And I'll go ahead and housekeeping matters 226 and 227.
Any objection?
No objection.
Okay, those will be admitted.
Not called record. And again, this has a similar label number.
Yes, it does.
Okay. Item number 4, similar lab number 22-19832.
Correct.
And was this item, although BCI received this item, did you analyze this item in any way?
No, this item was not examined.
Okay, is there a reason why it wasn't examined?
We looked at the fingernail clippings first.
Okay. And State's Exhibit 226. Can I have you identify State's Exhibit 226?
State's Exhibit 226 is BCI item number 5, which is a envelope containing Ms. Brewsaugh's right-hand fingernail clippings and a fingernail clipper.
Okay. And again, item number 5 is similar label, similar lab number 22-19832.
That's correct.
Okay. And did BCI, and did you do an analysis on State's Exhibit 226?
Yes.
Okay. And again, based on your training, education, experience, and your analyzation of State's Exhibit 226, do you have an opinion as to a reasonable degree of scientific certainty as to whose DNA is on this item?
Yes, they do.
And what is that?
The DNA profile from the right-hand fingernail clippings, specifically a sample from the stain, is also a mixture of DNA profiles. The major profile is consistent with Ms. Brewsaugh. Toby Madden is not the major contributor, and the additional DNA on this item as well is not of sufficient quality for comparisons.
Okay. So we have no idea whose DNA that might be.
That's correct.
Could that still be Toby Madden's DNA?
I can't make any conclusions regarding who the contributor of that additional DNA is.
And then State's Exhibit 227. You recognize State's Exhibit 227?
Yes.
And what is State's Exhibit 227?
State's Exhibit 227 is BCI item number 6, which is an envelope containing Ms. Brewsaugh's right hand fingernail scrapings.
Okay. And were these analyzed by BCI?
They were not.
Similar reason why the left fingernail scrapings were not analyzed?
That's correct.
Bloods for this one. All right, State's Exhibit, for the record, 213. Do you recognize that particular exhibit?
Yes.
And how do you recognize that particular exhibit?
State's Exhibit 213 is BCI item number 7.
And I'll take that from you real briefly. And again, that has a similar barcode and label as the other ones do. Item number 7, 22-19832.
Yes.
If I can have you take out what is in State's Exhibit 213, please. And what sort of analysis was done on that particular exhibit?
This item was examined for the presence of possible blood. No blood was identified on this item, as well as 2 samples were taken for potential DNA analysis. However, those were not sent forward for DNA analysis.
Okay. But there was no blood that was found on that particular white foil leaf?
That's correct.
State's Exhibit 215. Do you recognize State's Exhibit 215?
Yes, I do.
And what is State's Exhibit 215?
State's Exhibit 215 is BCI item number 8.
And what is BCI item number 8?
BCI item number 8 is a knife multi-tool.
If you would, please open up State's Exhibit 215. And that also that's an item that was received by BCI?
Yes, it was.
And what sort of testing were you asked to do on the Swiss Army knife or the multi-tool knife?
The multi-tool knife was looked at for the presence of potential bodily fluids, specifically for blood. Each area that was tested on this multi-tool knife was negative, so no blood was identified. There were 4 different swabbings taken from different areas of the knife.
So let me stop you there. With the court's permission, I'd ask for the witness to be able to step down and show the ladies and gentlemen of the jury where, in particular, the knife was swabbed.
Permission is granted.
Or if you prefer, if you want to do it on the overhead, either whatever one is easiest for you.
Go over there.
Whichever is easier for you, yes.
Okay. So there were 4 areas of the knife that were swabbed. One of the swabbings was taken from this broken blade here. That is BCI item number 8.3. There was a swabbing of the handle, the red portion. That was BCI item number 8.2. There's a swabbing from the interior portion where this blade would have rested inside, and that is BCI item number 8.4. And then there's another blade that was also swabbed as BCI item number 8.1.
Okay. And all the opinions I'm about to ask you about, based upon your training, education, and experience, and within a reasonable degree of scientific certainty. Okay, is that fair?
Yes.
Okay. And what findings did you make on State's Exhibit 215, BCI item number 8, the Swiss Army knife or the multi-tool knife?
Yes. So BCI items number 8.1 and 8.3, the swabbing from the blade as well as the swabbing from the broken blade, the DNA profile obtained from those items was not of sufficient quality for comparison due to insufficient data. So simply put, there just wasn't enough DNA present to make any conclusions regarding that DNA profile. The DNA profile from the swabbing of the handle had the same conclusions. There was not enough DNA present to make any conclusions regarding the source of that DNA. And lastly, BCI item number 8.4, which is the swabbing from the interior knife from the broken blade where that blade sits deep down inside. The DNA profile from that sample was a mixture of DNA profiles. So again, more than one contributor is contributing to that DNA profile. The major DNA profile was consistent with Ms. Brewsaugh. Mr. Madden is not the major DNA profile, and there is additional DNA present, but I cannot make any conclusions regarding who could be the source of that DNA as well.
Is that an unusual place to find DNA on the knife to you?
In my opinion, yes, somewhat, because as you saw, it's a very hard place to even get your fingers down into. However, if someone's handling the knife on a regular basis and opening and closing that piece, their DNA might be transferred there.
State's Exhibit, State's Exhibit 217, item number 9. If you wouldn't mind telling us what that is, ma'am.
Yes, BCI item number 9 is a shirt.
You can go ahead and take the shirt off here, please. And what sort of tests were conducted by BCI on this particular item?
BCI would have looked at the stains on the shirt and tested those to see if they would be presumptive positive for blood. And there was also a sample collected from the stain to be potentially sent forward for DNA analysis.
And what findings were there on the shirt?
The stain from the shirt was presumptive positive for blood. The sample that was collected was not sent forward for DNA analysis.
All right, State's Exhibit 231. And what is State's Exhibit 231?
State's Exhibit 231 is BCI item number 10, which are swabs from a bathroom sink.
And likewise, this item Do you recognize the labeling on State's Exhibit 231?
Yes.
And what do you recognize?
It has the unique BCI barcode with the BCI item number and case number.
The item that is contained within State's Exhibit 231, do you recognize any of the markings on this as well?
Yes, this has the BCI item number as well as our unique case number, as well as the individual's initials and date of when the samples were collected.
Okay. And would an analysis have been done on this particular item, State's Exhibit 231?
Yes.
Okay. And were you able to identify any DNA profiles contained on State's Exhibit 231?
Yes.
And I assume that you would use the same procedures that you've outlined before?
Yes, I did.
And based upon your training, education, and experience, and based upon a reasonable degree of scientific certainty, what results did you conclude as to whose DNA is contained in State's Exhibit 231?
The sample was presumptive positive for blood. The DNA profile was a mixture of DNA profiles. The major DNA profile was consistent with Ms. Brewsaugh. Mr. Madden Mr. Madden is not the major contributor, and there's also additional DNA present that I cannot make any comparisons or conclusions regarding who might have deposited that DNA.
So it could be Mr. Vans, it could not be Mr. Vans.
That's correct. I can't make any conclusions.
State's Exhibit 232. And what is State's Exhibit 232?
State's Exhibit 232 is BCI item number 12, which are swabs from a green jacket, the left lower region.
And again, you recognize the label that's on State's Exhibit 232?
Yes,
Item number 12, lab number 22-19832.
correct.
And the item is contained within State's Exhibit 232. Do you recognize any of the markings on this?
Yes, again, it has the BCI lab number, item number, and initials and date from the individual that collected the samples.
And this is an item that you would have tested or analyzed as part of your duties with BCI?
Yes, that's correct.
And were you able to develop were you able to develop any DNA profiles?
Yes.
All right, and then again, based upon your training, education, and experience with a reasonable degree of scientific certainty, what conclusions did you come to?
The DNA profile, the sample from that item was presumptive positive for blood, and the DNA profile obtained from that item was a mixture of two individuals. The major DNA profile is consistent with Ms. Brewsaugh, and the minor DNA profile is consistent with Mr. Madden.
And what statistical probabilities did you come up with on those?
For the major DNA profile, the estimated frequency of occurrence of that major DNA profile is rarer than 1 in 1 trillion unrelated individuals. As far as the minor DNA profile, the estimated frequency of occurrence of the minor DNA profile is rarer than 1 in 1 trillion unrelated individuals.
Thank you. State's Exhibit 233. 233.
States Exhibit 233 is BCI item number 13, which are swabs from a green jacket, the middle left region.
Okay. I assume you recognize the label that's on 233?
Yes,
Item number 13, lab number 2219832.
that's correct.
And do you recognize any of the markings that are within State's Exhibit 233?
Yes, this contains the similar markings of the BCI case number, item number, and initials of the individual who collected the samples.
And what sort of analysis was done on State's Exhibit 233?
These samples were tested for the potential to have blood. They were presumptive positive for blood, and no DNA analysis was performed on these items.
In State's Exhibits 234 and 235. Do you recognize those items?
Yes, I do.
And what are those items?
States Exhibit 234 is BCI item number 15, which is swabs from a gray button shirt, the lower left edge. States Exhibit 235 is BCI item number 16, which is swabs from a gray button shirt, right sleeve front.
And do you recognize the markings on State's Exhibit 234?
Yes.
Again, item 15, lab number 22-19832.
Yes.
And do you recognize the markings on what is contained within State's Exhibit 234?
Yes.
And what markings do you recognize?
Yes. There is the BCI case number, item number, as well as analyst initials.
And were you able to analyze State's Exhibit 234 and attempt to ID any DNA profiles?
Yes.
Okay. And based upon your training, education, and experience, within a reasonable degree of scientific certainty, what were your findings in regards to State's Exhibit 234?
The sample from the swabs was presumptive positive for blood. There was a mixture of DNA profiles on this item. The major profile is consistent with Ms. Brewsaugh. Mr. Madden is not the major contributor, and there's also additional DNA present that I cannot make any conclusions on.
And what is the statistical analysis on State's Exhibit 234?
The estimated frequency of occurrence of the major DNA profile from the swabs from the gray button shirt, lower left edge, is rarer than 1 in 1 trillion unrelated individuals.
And I know you've already identified State's Exhibit 235. This is the one where it needs to be opened. And then this is
It's open.
Is it? Okay. Hold on. I thought I had opened it. On State's Exhibit 235, again, do you recognize any of the labels on this?
Yes, it has the BCI barcode on it.
Item number 16, lab number 22-19832.
Correct.
And do you recognize any of the markings on what is contained within State's Exhibit 235?
Yes, it has the BCI lab number, item number, as well as analyst initials and date.
And were you able to analyze this particular item in regards to trying to identify any DNA profiles?
Yes.
And again, the same procedures that you've been talking about throughout your testimony?
Yes.
Okay. And based upon your training, education, and experience to within a reasonable degree with scientific certainty, what were your conclusions?
The sample from the swabs from the gray button shirt, right sleeve front, they were presumptive positive for blood. There was a mixture of DNA present on that item. The major DNA profile is consistent with Ms. Brewsaugh. Mr. Madden is not the major contributor, and there is also additional DNA present that I cannot make any conclusions regarding the contributors.
And then lastly, I believe there was one other item that you were asked to look at. State's Exhibit 216. And what are we looking at inside of State's Exhibit 216?
State's Exhibit 216 is BCI item number 17, which is a cigarette.
And was that an item that was tested by BCI?
Yes.
And based upon your training, education, and experience to within a reasonable degree of scientific certainty, what were your findings in regards to the cigarette?
There were two samples collected from the cigarette butt. One was a swabbing of the cigarette, and the second was a cutting from the paper that would have come into contact with someone's mouth if they were to smoke that cigarette. The swabbing from the cigarette butt was not sent forward for DNA analysis. However, the cutting was. The DNA profile from the cutting was consistent with Mr. Madden.
Was there a statistical probability on that one as well?
Yes, the estimated frequency of occurrence of that DNA profile from the cutting of the cigarette butt is rarer than 1 in 1 trillion unrelated individuals. And I should also mention that Ms. Brewsaugh is excluded from that sample.
Ms. Daly, I think I had you identify State's Exhibits 239 and 240. So State's Exhibit 239, is that a lab report that you would have generated?
Yes.
And the date of that report would be December 1st of 2022?
That's correct.
Okay. And then it's my understanding that at a later point, the cigarette was delivered to your lab for testing, is that correct?
That's correct.
And that's what would have made you generate a second report, which would have been 240, is that correct?
That's correct.
Because that would have contained the findings from the cigarette, is that correct?
Yes.
Okay. And then explain the difference then between State's Exhibit 239 and 240.
State's Exhibit 239 would have included also items that were not examined, items that had DNA profiles that were developed that were not sufficient for comparison, and it also contained all of the bodily fluid testing within that report. Those are things that would not be carried forward to a second report.
Okay. So 240 is kind of a summary. And the date for the State's Exhibit 240 is February 21st, 2024. So State's Exhibit 240 would essentially contain a summary of 239 with the addition of the findings in regards to the cigarette?
Yes.
If I can have one more. have no other questions, Your Honor.
All right, thank you. Cross-examination.
Good morning, Ms. Daly.
Good morning.
I have a few questions for you. I want to first, I know Mr. Burris went through everything with you, but I just want to kind of summarize, if I can, real quick with you. So you still have your report with you?
Yes.
So I want to start just to kind of go back over some of this, make sure I'm clear. So you analyzed the left-hand fingernail clippings of Rachelle, correct?
Yes.
And you were not able to make any conclusions of whether Toby Madden's DNA was within her left-hand fingernail clippings. Is that what you said?
He is not the major contributor, and I can't make any conclusions regarding the additional DNA that is on that item. So I can't include, exclude, or even call inconclusive.
Okay. And is the same? Is that the same for her right-hand fingernail clippings as well?
Yes,
You were given 2 knives, correct?
that's correct.
One of the knives, it looks like item 7, no blood on that knife at all. Is that? Am I reading that right?
The sample from the blade was tested for potential blood, and that was negative.
So did you get just a swab, or did you get the actual knife to look at?
We had the knife.
Okay. But one of the folding knife, no blood on, just to come back to that, right?
No blood on the blade.
Okay. And then the knife, your item 8 says knife, multi-tool. There was no blood found on that, correct?
Yes, the samples that were tested for blood were the swabbing from the blade, the swabbing from the broken blade, as well as the interior knife from where the broken blade sits.
Right. Well, my question was there was no blood detected on any of that, correct?
There was no blood identified on the samples I mentioned.
Okay. But you did say that looks like item 8.4, there was some of Rachelle's DNA on the interior knife from broken blade. Am I reading that correctly?
Yes, the major DNA profile was consistent with Ms. Brewsaugh.
But what you found was not blood, or what kind of DNA was it?
The sample was negative when we did our presumptive test for blood. So as far as where that DNA came from, I can't conclusively say. It could have been from skin cells. It could have been from some other bodily fluid that wasn't tested.
Okay. That was what I wanted to know, because, and I'm probably not saying it right, but sometimes when we find DNA, it could be my blood, it could be my skin cells, it could be sweat, saliva. But item 8.4 that you tested doesn't have blood.
Correct. There was no blood identified on that.
So if there's any DNA of Rachelle that's some other form, like skin cells or whatever, that other than blood, is that fair?
Yes. I can't say what, though.
Right. Do you have any knowledge that this knife that was found was actually inside Rachelle's purse?
Yes, I did know that.
Okay. Because you said it would be unusual to find DNA on that part of the knife, but you would agree with me it wouldn't be unusual if it's a knife that's in someone's purse that they may use almost every day, correct?
I would be more expectant to find her DNA on the exterior of the knife, so when we swab the handle, I would expect to find her DNA there. This is kind of just an odd place to find DNA, since it's really far deep down inside, and you can't theoretically even stick your finger down in there.
Right. Have you ever used the multi-purpose tool? Have you ever used one of those?
Rarely.
Well, when you saw it, do you see that there's little slivers in the top of each blade where you almost have to put your fingernail on to pull the blade up? Did you see that?
Yes.
So you're saying it would be uncommon if I'm opening that up, using my fingernail, my skin cells to pull a blade up, that it would be uncommon for my skin cells to be within the knife?
Not necessarily. I would expect your skin cells to be on that portion where you're contacting it and pulling it up. But this sample was taken from deep down in that groove.
Okay. Have you ever used a knife to clean your fingernail beds out?
Not a knife, no.
I understand, but not everybody does things the same way. Would you agree with me on that?
That's true, yes.
Could you, I know you're not going to do that, but could you use the end of a knife such as what you looked at just to kind of clean your nail beds?
You could.
Right? Okay. Also, with regards to, I think it was the bright green shirt, you said that was positive for blood, but the steps weren't taken then to determine exactly whose blood that was. Is that fair?
Yes, that's correct.
Now, item 12 is a green jacket, and that's one of the pieces that you analyzed, and you said that Toby Madden was a minor DNA profile. Do you remember saying that?
Yes.
For item 12? Do we know what DNA that is that you found there? Is that skin cells? Is it sweat, saliva, blood? Do we know what that was?
The sample that was collected was presumptive positive for blood. I can't say whether his DNA profile was as a result of his skin cells being deposited on that item or if it was also his blood.
And the clothes you have on today, the clothes I have on, every time I touch my coat here, touch my tie, I'm depositing DNA and cells all over my clothing, correct?
That's correct.
So it's not unusual for a piece of clothing to have someone's own DNA on it, right?
Correct.
Okay. Judge, can I have a minute?
Sure.
No further questions, thank you.
Okay, any redirect?
I think I just have one redirect
Okay.
question. There was some of the DNA that you tested that you were not able to make any conclusions as to whose DNA it is that correct?
That's correct.
And why would that be?
It could be for a couple reasons. The amount of DNA that was recovered from that item doesn't give a reliable enough DNA profile, so it doesn't meet our standards for comparison. It could have also been the quality of that DNA profile doesn't lend itself for comparison, or there could have been a number of individuals contributing to that DNA profile, making it also not sufficient for comparison.
Thank you, ma'am. Nothing else, Sean?
No recross, Mr.
Okay. Ma'am, you may sit down. Thank you.
The council clerk.
Sure.
All right. So the clippings, her fingernail clippings were Rachelle. I mean, that makes sense, but Toby is not a major contributor. So we can't say that she was fighting and she's scratching. He's got scratches on him, but he's not a major contributor. There was no blood on the Swiss Army knife. I mean, it makes sense that he cleaned it because there was a strong smell of rubbing alcohol. But the detective did say that there was residue on it, but he couldn't say what kind of residue. The handle and the broken blade of the knife were swabbed, but the DNA was not sufficient. So the stain on the shirt. Oh, the bathroom sink. That was a big one. That was Rachelle. So that one was a big one. The green jacket, Rachelle's DNA. The gray shirt, Rachelle's DNA. So as much as I wanted that DNA to be more of a slam dunk, I think it was enough to show that was her DNA was on, and the presumptive blood was on the shirt and the jacket, which is essentially the vest. Now, what's confusing me is still this jacket. He had the shirt on and then the jacket over that, and those had multiple cuts, and he didn't have any puncture wounds on him. So that's what's confusing. That's what's confusing me is like, how did all those defects appear? And I know if he's fighting, they're struggling.
Statement calls next witness.
Yes, Your Honor. The state will call Tanya Cook. If I may have a second. And my conversations with this witness, she does not wish to be recorded. I'm sorry, video.
Brett, he left something on the projector.
I seem to do that a lot.
You may proceed.
Good morning, ma'am. I appreciate you being here. Would you please state your name for the record and spell your first and last name?
Tanya Cook, TONIA-COOK.
Okay. Do you know an individual by the name of Rachelle Brewsaugh?
Yes,
How do you know Rachelle Brewsaugh?
we were friends.
Okay. How long have you known Rachelle Brewsaugh?
I knew her when we were younger, and then we played ball against each other, and then as we got older, because of Toby.
Okay. Are you a little nervous being here?
Just
Yeah.
Okay.
We need that microphone
Yes.
for the witness.
May I approach?
Yes, thank you.
We're having some difficulty hearing this, so
Okay.
let me, if I can ask that last question again. How is it that you know Rachelle Brewsaugh?
We are friends.
How long have you guys been friends?
When we were younger, we played ball against each other, and then probably 5 years
Okay.
as adults.
All right. And do you know an individual by the name of Toby Madden?
Yes,
You see Toby Madden in court today.
yes.
Would you please point to him and describe for ladies and gentlemen of the jury what it is he's wearing?
A blue dress shirt
Okay.
with stripes.
Your Honor, that's a record to reflect the witness has identified the defendant, Toby Madden.
The record will so reflect.
Okay. And ma'am, I want to direct your attention back to around Christmas time of 2021. Did you have contact with Toby Madden around that time?
Yes,
Did you hear him say anything about Rachelle Brewsaugh?
yes.
What did he say about Rachelle Brewsaugh?
Objection.
Overruled.
You can answer, ma'am.
He said that he would cut her head off, put it in her mom's lap, so the whole family would have to suffer.
Thank you, Judge.
Cross-examination?
Ms. Cook, that was pretty quick. Are you Toby's cousin?
Yes.
What makes you think that?
Our grandmas are sisters.
What grandma? What's her names? Those two.
My grandma Venerable and his grandma, they were Molly and Polly Venerable,
Okay.
or Croucher or something, I don't know the last name.
Did you get involved in this case where someone reached out to you, or did you call down the police department?
I called them.
Okay. This statement that you just say you heard, you said he was going to cut off her head and put it in his mother's lap?
Not
Or her
his
mother's
mother's, her mother's. That's before she passed away.
Okay. Who was around when he said that?
My daughter, my husband. He said it over and over again. It wasn't just one time. It was over and over again.
When you say over and over again, you talk about just that day?
No, just different days.
Okay, so I'm assuming you called the police, right?
When he said that?
Yeah.
No, I did not.
All right. You said he said this in the presence of your daughter. What is her name?
Haley Cook.
And you said it was in the presence of your husband?
Yes.
What's his name?
Chris Cook, Warren Cook.
Where were you at when this was said?
At my house.
What were you guys doing?
Toby would sell clothes and shoes, and
Were you selling clothes and shoes inside your house?
he would bring them in his truck, and I would buy shoes from him or clothes, whatever.
Okay, so when I asked you what you were doing that day when he said this, you're buying clothes and shoes from him?
Yeah, it's depending on what day it was. Like I said, he has said it over and over
I'm asking you about the day that he made
again.
the statement. What were you doing that day that he made this statement?
I don't know. We were maybe sitting on the couch. I don't know exactly. We were talking, sitting there.
You remember what day it was?
No,
Day of the week?
no, because he said it quite frequent. It was either he was going to stab her to death or cut her head off and put it in her mom's lap.
Where was he at inside your house when he said this?
It would be like right next to me on the couch.
All right, so he was inside your house.
Yes.
Correct? And your husband was there?
Yes.
Were you drinking that day?
I don't drink or do drugs.
But your husband does, though, right?
Yes.
Was he drinking or using drugs that day?
I don't know.
Well, how long have you been married to him?
22 years.
You can't tell us whether or not your husband's drunk after 22 years of being with him or on drugs?
He possibly was on drugs that day.
Did you ever take Toby to the hospital to see Rachelle's mom?
No,
Never?
never,
Did you ever take Toby anywhere to go see Rachelle's mother?
never.
Okay. Did you ever see Toby around her mother? Were you able to observe the two of them together?
No,
Did you ever see at your house Rachelle hit Toby with a stick?
it was a thing that you put up underneath the doorknob
Yeah.
to keep people from coming in. He had come to the house. Rachelle was there, and I could tell by his knock that it was him. I was like, "That's Toby, Rachelle." And so she got up and answered the door, and he had the stick, and he hit her with it.
Oh, he hit her?
Yep.
Did she ever hit him with a stick?
She took it back she got it from him and hit him with it.
If State was put up, Exhibit 66, please.
I'm sorry.
I'm sorry, State's Exhibit 66.
Sorry.
If you wouldn't mind. Since you're connected, my computer's on.
I'm just talking to Mr. Holmes.
Can you see, is there a screen in front of you that has that, ma'am?
Yeah.
Does that look like the stick that Rachelle would have hit Toby with?
No.
It doesn't?
No, it would have
That's it?
underneath. It was like silver.
What color is this object?
I can't tell the color of that. That's not it.
You said this thing, whatever this, Rachelle used to hit Toby, was it metal?
Yes.
And you said it went under a door?
It was to help secure your door in your house. You stick it underneath your door. But Toby was the one that came and hit her with it first.
Right, but you're not denying that she then grabbed it and hit him, correct?
No, I'm not denying that. She did.
They had a really hot and cold relationship, didn't they?
Well, I mean, she was defending herself.
Was that a yes or no? Did they
Hot
have a
and
hot
cold
and cold
relationship? Yeah, she was trying to get away from him, so it wouldn't be hot and cold anymore.
I understand that, and I'm not trying to disrespect that she's passed. I'm going by what you saw between these two, because the reality is on the day that she is stabbed, you don't know what happened inside
No, I
that
do
house,
not.
do you?
No, I
But
do
you do know that they have a rocky relationship, don't you?
Yes.
And you do know that she hit him with the stick, whether he used it first or she used it first. You've seen her hit him with the stick
Yeah.
that goes under a door.
Yes.
Did you ever go as far as to tell the police that Toby pulled a gun on her?
No, I did not.
You didn't do that? Judge, can I have a second?
Sure.
No further questions.
Anything else?
There you are. Thank you.
Okay, ma'am, you may step down. Thank you.
Yeah, counsel.
Yes, please.
On behalf of the state of Ohio, I believe Ms. Cook is released from the state's subpoena.
Very well.
All right, so that was Toby's cousin and as well as a friend of Rachelle's. So Christmas, she heard Toby say he would cut off Rachelle's head, put it in her mom's lap so the whole family would have to suffer. Yes, that was Polly. Kaylee, that was little Polly. Good eyes. So apparently this was a tempestuous relationship. There was another toxic relationship. Well, don't know how toxic it was, but certainly toxic enough that he would say something like that and apparently hit her with a stick. Yeah, yes, she is a sweet girl. She is a sweet little girl. Yes. She's my snake fighter, my snake warrior. She took on a pit viper and survived. So, while we wait here, I don't know how much is. We're taking a long time. All right, we'll just stay here. Because then we have day 4 to go through as well, which will be. Yeah, he's like, I got questions. Remember, he wanted to represent himself. And here comes Queen Super Ball. Not to be denied of some petting. Yes, thank you for putting your butt in my face. Thank you. Okay, that's a good girl. All right. There you go, Super Ball. All right, so the DNA, Rachelle's DNA was on the green jacket, was on the gray shirt, was in the bathroom sink, right? Bathroom sink, presumptive for blood, consistent with Rachelle. So those were pretty big moments. I'm surprised that there was his DNA was not under her fingernails. Although it says Toby is not a major contributor, so they couldn't rule him out. They couldn't rule him in.
Okay, ladies and gentlemen, it's the court's understanding that the state has presented its last witness to you. So at this time, we need to take care of some business outside of your hearing. So I'm going to go ahead and release you a little bit early today so that we can take care of that. We'll come back at 9 o'clock tomorrow morning and proceed from there, okay? But please remember my recess instructions. Please be seated. So the jurors have been excused from the courtroom, and at this time, would you like to take out the exhibits?
Yes, Your Honor.
Okay.
So I believe State's Exhibits 1 through I think 1 through 206 have all already been admitted.
And that's what my recollection is as well. However, there is no Exhibit 177, is that correct?
Correct.
Okay. So that takes us to 207, and go from there.
So, Your Honor, I believe the coroner's report is a self-authenticated document. It is certified. I think it comes in that way without any testimony.
Any objection?
Hold on one second.
Okay.
I was just catching
Sure.
up, make sure I didn't have Yeah, you're talking about 207?
Yes.
Yeah, that's fine.
Okay, so that'll be admitted. And then I have 208, 209, 210, and 211 being admitted, 212 being identified but not admitted. That is the wallet.
I am asking for its admission and/or photographs one way or the other. I know it's a wallet, and I think there's under a driver's license and stuff like that. So whatever the court's preference is, I can just.
You said are there photos of it?
No, I said we could either introduce that as an exhibit or we would take photos of it. It's going to be 212.
I'm assuming your ID's probably expired. Your driver's license? Yeah. You can send the wallet back. I was just making sure there's.
Okay, well, there's also a dollar bill as well.
Yeah.
A couple dollar bills.
No, it's fine. That can go back.
All right, so we'll admit that.
For like Social Security stuff, nothing.
All right.
Okay, well, go ahead. Issue date 95. Expires 2/17/2022.
That's fine. The wallet can
All right,
go back.
we'll admit that. And then I have 213 as being admitted, 214 as being identified but not admitted. That is the black book bag.
I'd ask for its admission now. And probably,
Any objection to the book bag?
No.
Okay, that'll be
if I
admitted.
asked your bailiff, I've gone through it, but if the bailiff would like to go through and make sure that I don't believe there's anything in here that's harmful or anything, but
If you would do that, Mr. Halcomb. Okay. All right. So then the next, I have 215, 216, 217, and 218 is being admitted, 219 and 220 being identified but not admitted. That would be the gray hat and the Kroger bag.
I'd ask for this to be admitted.
No objection.
Okay, those will be admitted. And then it appears there is no Exhibit 221.
Correct.
Okay. So 222 I have as being identified but not admitted.
I'd ask for it to be admitted.
No objection.
Okay, that'll be admitted. And then I have 223, 24, 224, 225, 226, 227 is being admitted. And I do not have 228, 229, or 230 being identified or admitted.
Correct. There will be no exhibits there.
Okay.
What were those again? I'm sorry.
228, 229, and 230.
Okay. Got it.
All right, and then we've got 231. I have 231 as being admitted, and 232, 233, 234, and 235 as being identified but not admitted.
I'd ask it to be admitted, Your Honor.
No objection.
Okay, those will be admitted. And then 236, I do not have a record of that being identified or admitted.
Correct.
Okay. I've got 237 and 238 as being admitted, 239 and 240 as being identified but not admitted.
I'd ask that they be admitted.
No objection.
Those will be admitted. I have 241 as admitted, 242 and 243 as being identified but not admitted.
I'd ask that they be admitted.
No objection.
Those will be admitted. And then I have 244, 245, 246, 247, 248, 249, and 250 is all being admitted.
Yes, Your Honor.
Okay, are there any other exhibits that we have not addressed?
Nothing other than what we discussed, and no other exhibits other than what we discussed in site court.
So with those exhibits being admitted, is the state going to have any other evidence?
The state has no other witnesses to present, no other evidence to submit in the state arrest.
Very well. And of course, we'll let you do that in front of the jury tomorrow.
Yes, Your Honor.
Okay, now that the state has rested, Mr. Wilder, is there anything you'd like to put on the record?
Judge, at this time, we would make a Rule 29 motion for acquittal on all charges. I just argue that the state, even construing evidence in the light most favorable to them, have not provided sufficient evidence on all the elements of all the charges presented. Thank you, just
Thank
General.
you. Anything that the state wishes to put on the
I
record?
believe that we have put sufficient evidence forward to warrant the case go to the trial fact.
All right. All right. Well, the court has carefully listened to the evidence, and considering Rule 29 and the appropriate standard in that rule, the court is going to respectfully deny the motion. Okay. Anything else that anyone would like to take up today before I take up a few items?
Nick,
Not at this time, Judge. Obviously, I'm discussing with Mr. Madden his case and whether he's going to testify or not. And once that decision is made, that will obviously be something that I'm not sure what this county does or you yourself, Your Honor, but that may have to go on the record.
Very well.
But nothing other than that.
All right. Well, that brings me to the jury instructions that I wanted to discuss with you. And in those instructions, we have started out by saying that Mr. Madden would not testify, but certainly we will amend that if, in fact, he chooses to exercise his right to testify. So I'll have that language prepared to go either way based upon what happens with the case as we proceed. Other than that, Mr. Burris, Mr. Hahn, do either of you have any comments, corrections, or requests to the draft jury instructions that I have provided?
I don't believe so at this time, Your Honor. We don't know.
Sure, and I understand we probably have to conference again, but I just want to have them in the best position possible so that they're easy for us to modify and alter as we proceed. Did you have anything that you wanted to change or add, Mr. Wilder?
Judge, I don't see anything with what's printed out here. However, based on some of the testimony, there is a potential that we may be requesting an instruction on voluntary manslaughter. I will certainly file something as a formal record, but other than what was printed out, I don't see anything in there at this point. But if anything additional like that instruction is requested, I can certainly file something and obviously bring it to the court's attention.
All right. Well, then I will leave them unchanged at this point, and if the defense chooses to present a case after that, we'll conference again and see if we need to make any other changes.
All right. Thank you.
Okay. Anything else before we recess for the day?
I assume it would be the court's intention to try and get this, this case to the jury by sometime tomorrow. We'll stay as late as we're going to stay.
If we are still presenting evidence or doing closing arguments, or if we're not finished with those things, I would anticipate asking the jurors if they would like to stay or not. If we're in deliberations, likewise, I will ask them if they wish to stay. So I'm largely going to leave it up to the jurors. So if you would be prepared to stay past business hours, if that's how they choose to proceed.
That's right.
Okay. Anything else?
I don't have anything right now.
All right. All right. We'll see you all tomorrow morning at 9 o'clock. Thank you.
That's right. Thank you.
Thank you.
All right, so we're going on to day 4, state rests, but they're going to do it in front of the jury. I'm just going to wait until he actually leaves, because even walking out of the courthouse or courtroom, there's something happens with him almost every day. Walking in or out of the courthouse, he always seems something happens. We'll just wait. I don't want to fast forward or stop just in case something happens, because every day he's done something. Paul, everybody do their Toby take the stand dance. Gordon, yeah, he is like a coiled spring. I agree. You just never know what's going to happen with him. Right now he seems fairly controlled. And Bing and Billy, thank you for the cups of coffee. Appreciate that. Thank you so much. I'm so happy to be here. Your channel is the best. Thank you. Thank you and your mods for all your hard work. Thank you, Bing and Billy. Really appreciate that. And Debbie, need to learn to read lips. Yeah. All right. How much more time do we have here? It seems like it's almost over. All right. Yeah. He just kind of talks with the guy. Talks with his lawyer. All right. Let me fast forward just a little bit, because now he's just seems to be under control. Just do a little zooming here through here. Well, whatever it is they're talking about, it's definitely not heated. I don't know what they're talking about. Maybe the exhibits? All right. So if you look at his like his chest and his back area, he definitely has like two coils, if you will, going around his back area. So I think that's like a shock vest or whatever they're called. William, him and his counsel for sure don't connect. Yep. Well, remember he had like six attorneys. He wanted to represent himself twice. Oh, he was allowed to have a pencil? Wow. Yeah, see that thing around his middle of his back there? There's like two coils. I think that's like he's wearing like a shock vest. All right, Pook, we can't have that kind of language. Appreciate you coming in and talking, but yeah, we can't be swearing on here. He put some papers in his shirt pocket too. Yeah, usually they're given like a rubbery, soft utensil. Like they're usually not given a pencil or a pen. It's usually like something soft, so they obviously can't stab somebody. Crispy Dino Nug, thank you. Thank you for being with us. All right. So generally he's not creating a hubbub. Wow, four bailiffs though, 4 sheriffs. Follow him out. All right. So that is day 4. Now let's get to day 5. This is going to be closing statements. Oh, well, wait. We have to see if we know the state is rested. Let's see if the defense has a case. I know this is the last day, so we'll see if they put on a case or not. All right, hold on. Let me get us queued up here. All right. So here's day 5. So what do you think? Do you think the state met their burden? 97% of you said yes, Toby is guilty. 3% say no, Toby is not guilty. Did the state meet their burden? I think the blood in the sink and then on his clothes, that's pretty obvious. I thought having DNA found could have been more persuasive, but they did what they did. I think having Rachelle's blood on his clothes, even and remember, he was giving CPR to her when law enforcement showed up, and that was a different shirt. So that shirt had blood on, which is understandable because he's giving her CPR. But to have the blood on his vest and that shirt having Rachelle's blood, DNA, that to me is pretty pretty damning. And then of course blood in the sink, that's Rachelle's blood. He claims he slept. He woke up and he found her. So that doesn't make sense. This would have been a brutal attack. She would have been fighting, screaming. Although the neighbor only heard one scream, but she definitely would have been. There would have been a lot of noise. I don't think you're going to sleep through that. And then what's the other thing? The one thing that's sticking with me though that is I'm trying to understand it or justify it is that here we can come here. I'm trying to understand and justify it that how did he get those the cuts, the defects in the vest and then the shirt, and then he had no puncture wounds on him. He only had a couple scratches on his chest, I think on his back, his arms. But if she had grabbed that knife and she was stabbing at him, he would have had something, right? He would have had something on his skin. And it wasn't just like one or two. I mean, it was like at least 4 or 5, maybe. So I don't know. Debbie, fake CPR. Yeah, he knew she was gone. Plus, that's like the last thing you want to do is do CPR on somebody who's got 55, injuries. Bama, yeah, Daryl Brooks was only allowed to have an insert of an ink pen. Yeah, maybe that's what I'm thinking of. I remember it was like soft. It was soft or something. I think, or crayons even. They just give them crayons, something like that. They don't even give them nothing sharp. All right, so let's get to, this is day 5. Let's get to day 5. Looks like he has the same shirt on. This is day 5, right? Yeah, day 5. Isn't that the same shirt? It's like the same shirt. Yeah, that's the same shirt he had on. That's the same shirt he had on the other day. Ruth Wally, I agree. I'd love for him to testify. He would, this if he does. I'm not sure if he does or not. I don't remember. But yeah, this would be ultimate ego takes the stand. Pippi, Daryl trial was the best. That one was pretty bonkers. That one was definitely bonkers. Yeah, Kaylee, I just rewound. He's got the same shirt. It's a gray with the white stripes. So he has the same shirt on. That's why I had to double check to make sure this is a different day, right? This is a different day. This is day 5. Well, we'll find out as soon as the even his attorney has a light gray jacket on. Debbie, thinking the same thing, same shirts. I don't remember what he was wearing the previous days, but okay, yeah, his lawyer has a darker jacket on, so this is a different day. But if you're just judging from his shirt, all right. Here comes the judge. Judges.
This court of common pleas in for Butler County. The Honorable Gentleman McGuffrey presiding is now in session.
Good morning. Back on the record in State versus Madden, CR 22-121-675. And Mr. Burris, Mr. Hahn, and Detective Horton are present on behalf of the state of Ohio. And Mr. Madden appears with counsel, Mr. Wilder. The jurors are not in the room. Before we bring the jury in the room, is there anything that the state would like to put on the record?
Good morning, Your Honor, and hopefully so. Thank you.
Okay, anything on behalf of the defense at this time?
Yes, Judge. This morning, we had a couple of witnesses who were going to testify. One of them is Mr. Madden's brother, Tim, who's in the courtroom today. I plan to call him, but it's my understanding that my client does not want that done, so I would want to put that on the record.
Very well.
He does not want that to occur.
All right, very well. Anything else you'd like to put on the record today?
We also had a neighbor, Tamara Dewar. She was here Monday and Thursday. I thought she was going to be back here today to testify. She does not appear to be here at this point. However, given some of the testimony by other neighbors and the reason she was going to be called, I think we have got into evidence, so I'm not requesting that her appearance be found at this time.
All right. We will be letting the state of Ohio rest, and would you like to present a case after the state has rested?
Your Honor, with those things that I just mentioned, the only other potential witness would have been Mr. Madden himself. So I don't know if this is the time to discuss that or not, because his decision whether to testify or not. So given that he doesn't want his brother and there's no other witnesses ready and available, Mr. Madden is the only remaining one. So I think we need that colloquy now.
All right. All right, Mr. Madden, you do have the right to testify in this trial. It is your constitutional right. Do you wish to exercise that right today?
No, ma'am.
All right, then we will let the state rest its case, and we will be prepared for closing arguments. Let's go ahead and take a seat, because I think we're going to have some other business then to take up, so we can move a little bit more smoothly through the process. Okay, so we'll be ready for closing arguments, and we talked about our jury instructions. I did see that you filed a proposed jury instruction. Mr. Wilder, I have reviewed your motion. Is there anything else you'd like to put on the record in support of your request?
No, Judge. Everything I would say right now is contained within my motion. It's filed as record, so I would stand on the motion and incorporate those arguments in the paper as if stated here this morning. So I would stand on my motion.
And does the state wish to respond to the request for the jury instruction?
So, Your Honor, voluntary manslaughter, I read as being defined as no person while under the influence of sudden passion or in a sudden fit of rage, either of which is brought on by serious provocation occasioned by the victim, as reasonably sufficient to incite the person into using deadly force, shall knowingly cause the death of another or the unlawful termination of another's pregnancy. Obviously, that part doesn't apply. While I certainly will probably, there'll probably be some arguments that stabbing somebody 55 times certainly seems to be a sudden fit of rage or sudden passion, I do not believe that there's any evidence that would suggest, or any evidence that we heard from this witness stand that says that was brought on by the victim, Rachelle Brewsaugh. So at this point, because that part is lacking, I would object to the instruction.
Okay, well, the court has reviewed the statute as well as State versus Amison, which is a 12th District Court of Appeals case 2021 Ohio 1537. And in that case, the trial court declined to give an instruction on voluntary manslaughter in a murder case, and the 12th District Court of Appeals upheld the trial court's decision. The court referenced State versus Gray, also out of the 12th District, 2011 Ohio 666 in its decision, and indicated that for provocation to be sufficient, it must be sufficient to arouse the passions of an ordinary person beyond the power of his or her control. And I quote from the Gray case that was referenced in Amison: if insufficient evidence of provocation is presented so that no reasonable jury would decide that an actor was reasonably provoked by the victim, the trial judge must, as a matter of law, refuse to give a voluntary manslaughter instruction. And the court has carefully reviewed the evidence that the defendant believes was proffered that would support the instruction. However, in this court's mind, the court does not believe there is sufficient evidence for it to give the voluntary manslaughter instruction. So it is respectfully going to deny that request. Anything else with the jury instructions that we have gone over to the court proposed previously?
I think all of them are standard issued OJI instructions. I would just ask for a new copy of what it is that's ultimately going to be read to the jury.
Okay. Any other requests or additions, Mr. Wilder?
Other than what we requested, I understand the court's ruling. I didn't have any other issue with the instructions as given to me.
Okay. All right. I'm going to use the same copy that I gave to you, but we will be printing them out for the jurors. If we make corrections during the course of that, I'll print up a new copy and make sure everybody has those before they go back to you.
I do. brief summary. Your Honor, when I read through the draft, I
Yes.
think the pronouns were wrong in
Okay,
some of the parts.
okay.
I think it said her, it should say him.
Okay, I will hopefully catch those as I
Okay.
read them and make the changes for the final copy that I'll provide to you and before it goes back to the
Thank you.
jury.
Judge, if I
Yes,
may,
sir.
I did note that Mr. Madden's decision, he just put on the record to not testify. Obviously, the language of him not testifying needs to be in the instruction.
That is.
Oh, we had it in that
It
he
says
would.
defendant
Yes,
does
sir.
testify, so obviously there needs to be language about him not testifying and accepting the standard language of not
Yes, sir.
used that against. So.
All right. Thank you for that.
Your Honor, if I could just add one more thing. I've asked him multiple times to subpoena some information that would show how this all started, and he's refused over a period of months. He's told me to my face that he's not going to subpoena the information, and that if I try, he said later on, you're just going to have to file an appeal. But I'm not, for the same reason that the neighbor that was next door to us, the mayor, the one who robbed the bank, there was on record, that she was saying that me and Rachelle both were great neighbors, and I don't look like somebody that would be a murderer. And, she was happy to have us, and she let me use the phone all these different times to call while we still were living. But he thought that wasn't sufficient enough evidence for the jury to hear, and I thought it was. He said, but if you try to bring that forth, I'm going to make sure that she shuts it down. Why would he have you shut that down? I don't understand, but listen, you've made a ruling. There's plenty of things that I thought that needed to come out. For example, when I asked him to ask the detective, this gentleman right here, when he ran down the hallway after I was beat up on March the 27th and taken down 2 hallways, dragged out of my shoes, down to the bottom of the basement, inside a cell, you could hear me screaming out. Why did he leave this courtroom and run down 2 hallways? Why did he come up to my face? What did he say to me? What? He goes, I don't. And then, when I said, hey, ask him if he knows Rachelle's niece who works at the front desk at the Hamilton Police Department in the same building that he works at. I just asked him if he how well he knows her. He refused to do that. So there's so many things that I thought that I just wanted to put on the record. And that's all I had to say right now.
Is there anything else, Mr. Wilder?
Judge, I'm not going to respond to the allegations because if I were to do that, I would be breaking attorney-client privilege, and I'm not going to do that at this point. I'm prepared to argue his case as best I can based on the limited discussion we've had about the case. Despite my many efforts and meetings with him, not having a lot of information about the situation that occurred has limited me, but I'll just leave it at that.
Well, one other thing. You know that on March the 27th, about near 9 a.m. 2024, I was brought in here in the afternoon, probably sometime. Most of the time I had hearings that were in the afternoon, 3:15, 1:45. Times that my family didn't even know that because times weren't being logged on the computer when I was having court. So nobody could be here. I was brought up with no other inmates. I was always and woken up out of my sleep, said, hey, you got a court date today. Having hearings without me there. But I was in the jury box and I said, hey, they were wanting to have a proceeding with me while I was inside there. And I said, a protest. And I said, hey, listen, I'd like to be at the desk, so that I could go on record. Because if at any time that there's been a proceeding or a hearing here, if you haven't heard my voice, then you can surely 100% know for a fact that I wasn't there. And being that I was not allowed to come over and sit at the desk, listen, and I protested. I didn't want him as an attorney. You know that I didn't want him as an attorney. And I told you all that. I don't want him as an attorney. And for that reason, it said get him. And I had the shoes beaten off of me all the way down the hallway, down 2 hallways, down to the elevator, and this man right here gets up for some reason and comes down the hallway.
I'm going to stop you, Mr. Madden.
And ask him what he said to him.
We've talked about some of this before.
Okay.
I've got your jury is waiting, and I don't want to keep them waiting. Okay?
Yes, ma'am.
So if you,
Yes, ma'am.
if everybody's prepared to go forward, we'll go on with the closing
Yes, ma'am.
arguments, and I'll have the jury instructions modified while we're doing that, and have them passed out to you before they're read to the jurors. But we will
But
change the language of that.
on the record, I did ask for that preservation of that footage. Of the footage when I was beat up at the jail too. So, but none of those things. Multiple times. But here we are.
And we're going to go ahead and bring in the jurors. Okay. Thank you. Please be seated. Good morning, ladies and gentlemen. Does anyone have any violations of the court's recess instructions to report? Okay. All right, we left off with the last witness being presented by the state of Ohio. How does the state of Ohio wish to proceed this morning?
Yes, Your Honor, at this point, with the admission of all the state's exhibits, the state has no other witnesses to present. Ladies and gentlemen of the jury, the state will rest.
Very well. And Mr. Wilder, does the defendant wish to present a case?
No, Your Honor. Thank you.
Very well. Okay, so ladies and gentlemen, you have now heard all of the witnesses, and you will receive all of the exhibits into evidence, and it's time for closing arguments. So please keep in mind that the closing arguments are not evidence. They are designed to assist you, and they are the attorney's views of how they think the evidence proves or does not prove the charges. So they are designed to assist you, but they are not evidence. Now, in accordance with the rules, because the state of Ohio has the burden of proof, the prosecution will go first with its closing argument, and after they have concluded, the defense will have the opportunity to present its closing argument, and then because of that burden of proof, the prosecution has the burden to give you final words in a rebuttal closing argument. So that is how we will proceed with this portion of the trial, and whenever the state is prepared to go forward, you may do so.
We move that.
Sure.
Thank you.
What do you want?
That's fine.
Yes, sir. What do you have numbers you want? Because it's
Do I need to set that up or push this? You got it. Thank you. May I proceed?
You may.
Good morning, ladies and gentlemen. Echo there. I'm going to read to you Toby Madden's own words. These are the words that he spoke on Monday before you entered the courtroom, before opening statements. I'm responsible for what happened to her. I didn't mean it. I'm so sorry. I love you. Please don't hate me. Can you put up State's Exhibit 181, please? This is what he's responsible for. You Put up State's Exhibit 40. This is the it that he didn't mean to do. 55 times he didn't mean it. Let me take that down. If you recall from my opening statement on Monday morning, I told you how every trial is like a puzzle, and that you receive pieces of the puzzle throughout the week. And that's what's happened this week. And you receive those pieces of the puzzle from the exhibits that have been admitted and from the witnesses that have testified. And I want to talk about those pieces that you've received all week long. And I want to help put them together for you. So we know, and I'm not going to go in the same order that they came in, but I'm going to try and put this in chronological order for you. So we know from Michaela Madden and Tanya Cook that the defendant and Rachelle were together for about 25 years, or north of 25 years. That they moved around from place to place. Michaela said they moved around from place to place, and they finally moved to 1270 Parish Avenue in the city of Hamilton, Butler County, Ohio, in the early of October of 2022, and that they were renovating this home and fixing it up to live there. We also know from Michaela that they had a rocky and on-again, off-again relationship. And we know from Tanya that the defendant had been seen hitting Rachelle in the past, and that he said that he wanted to cut her head off and put it in her mom's lap. And he said it multiple times. I'm not sure that rocky is the right word for that relationship. We also know from Detective Horton that on October 10th of 2022, the defendant went to the Kroger on Route 4 and Grand Boulevard here in the city of Hamilton. And that was in the evening. And you saw the video and the still photos. He had on a gray shirt, short sleeve shirt, button down shirt, a green vest, white shorts, and Nike Kevin Durant 8 shoes, or KD8s. And that was in the late evening around, I believe it was around 8 p.m. on October 10th. And the next pieces that you got were from the City of Hamilton utility workers. You heard from the 4 of them, specifically the 3 that went into the house. We know that there was an appointment that they had at 8 a.m. on October 11th in the morning, that they showed up on time, that Rachelle let them in, and that she sat on the couch, had a hold of their large, big dog. I believe one of them said it looked like a pit bull. All the furniture was in its place. The china cabinet was upright. The entertainment center was upright. There weren't any chairs overturned. Nothing was overturned. And that they walked through the house and they saw a male sleeping in a chair in the adjacent room. They went into the basement. They did whatever it is they were doing, running their test on the gas line, and they determined that they can't turn on the gas because the furnace is broke or it hasn't been fixed yet. And they go back upstairs, and they're leaving at about 8:25. They see the male still in the chair. I think he acknowledges a "what's up" to one of them. They tell Rachelle that they can't hook up the gas because the furnace isn't working. And that one utility worker told you that she then looks to her right to the adjacent room and gives a stare or a look to the male in the chair. And that when they left there around 8:25 in the morning, she was alive, she was well, still had a hold of her dog. Everything was fine in that house. And we know from Ann Mayers, who testified, that, as she did every day, as she said, she was on her porch at around 8:45 a.m. because she watches her sister's grandson with her sister walk to school at Crawford Woods Elementary, which is right down the street. After the grandson gets around the corner and heads up to the school and out of eyesight, her sister goes inside because she said her sister wasn't feeling well. So Ann sat out there, still drinking her coffee, looking at her phone. And she tells you that sometime between 9 a.m. and 10 a.m., roughly, she doesn't remember exactly, it was 2 years ago, that she hears a scream. You all heard it. She did it for you right here in the courtroom. And she said it lasted 5 to 7 seconds, and then it came from her left. And she's at 1260 Parrish Avenue. They're at 1270 Parrish Avenue on her left. But as she said, she doesn't know. There's a lot of kids in the neighborhood. There's a lot of screaming that goes on, but she heard this one from that direction, but she didn't do anything about it. She didn't call the police. Said she went inside and she ate breakfast. And from that time that she was out on her porch, she said there was no one else out there at 1270. She didn't see anyone. The utility workers had already left. And then the next thing we know is that Officer Katie Johnson arrives there around noon or 12:10 in response to a 911 call. She gets there. The defendant's inside giving CPR to a clearly deceased body. There's multiple stab wounds in the body. Officer Johnson saw that. She said the body was very pale and the intestines were protruding from the torso. She pulls the defendant off of Rachelle and takes him outside. At this point, he's got on a lime green shirt, shorts, and Reebok shoes. Officer Johnson told you at that time there is no signs of forced entry in that house. So when you look at the timing from when Ms. Mayers told you that she heard that scream, and by the time Officer Johnson gets there, the defendant had roughly 2 hours to be alone in that house with Rachelle. And you heard from numerous detectives about the scene and their investigation and the pieces of the puzzle that they give you. When they get there, there's no forced entry. Front door jamb is fine. The back door, it does have a dent in the door, but it's got 2 deadbolts. You saw the picture of that. That door's locked. It's secure. Rachelle's lying dead in that front room with multiple stab wounds in her body. That front room is in disarray. Furniture's overturned. You saw the cabinet on the floor right next to her. There's blood everywhere, on the walls, on the floor. It smells like rubbing alcohol, and there's 2 empty bottles of rubbing alcohol in that room near her. And then in the basement, which is completely dark, if you remember, those detectives told you, there's no electricity down there. They had to light that up themselves. They find the green vest, a bloody green vest. Turns out there's the bloody gray shirt down there, which, yes, they didn't get that until about 15 days later because of the Kroger video. But they don't find any white shorts or any Nike KD8s. There's a wooden board on the ground next to Rachelle's body with 2 distinct shoe prints on it. one of which is that Reebok shoes that he was wearing when the police got there. And the other one, as Detective Horton told you, as he found on the internet, is a shoe print of a Nike KD8. There's blood in the bathroom sink and on the bathroom floor. And keep in mind, he had roughly 2 hours from the time Ann heard that scream to when the police got there. They find a Swiss Army knife in Rachelle's bag. And it appears to be wet when Detective Horton finds it. Detective Trenum tells you when he examines it, it appears to be rinsed or washed. And it's got a deformed blade, a broken blade, that matches and is similar to the tears in the fabric in the green vest and the cuts in that Planet Fitness shirt that Rachelle was wearing. And you know from Detective Horton that the defendant told him, you got to find those 3 city guys. You got to find them. There's people out to get me, but there's not anybody that I know that wants to hurt Rachelle. And then Catherine Daly from BCI supplies you with these pieces. Rachelle's blood is on Toby Madden's green vest. Rachelle's blood is on Toby Madden's gray shirt. Rachelle's blood is in that bathroom sink. And Rachelle's DNA is down in the well of that Swiss Army knife. Down in a part where, as she said, you're not going to stick your finger down in there. It's not going to fit. And we know from Dr. Updegrove that Rachelle died from 55 stab wounds. They were on her arms, they were on her leg, they were on her torso, they were on her head, and one in the back. And he told you that there were defensive wounds on her hands and her arms, the bruising on her hands. He also told you there was a small knife that was used. And he told you that when you look at those pictures, the darker wounds are because the blood was still pumping. Her heart was still pumping. And those lighter wounds, they came as the life was slipping away out of her. You put these pieces together, and I submit to you that this is what you get. You got 3 City of Hamilton utility workers that leave that house and everything is fine. Something happens at this point. It's a piece we don't have, because the only 2 in that house are the defendant and Rachelle. Maybe she says something to him about the furnace. We don't know. But he goes off. And ladies and gentlemen, there's 1 stab wound in the back. And I submit to you that that's the first one. He attacks her from behind. He stabs her in the back with a Swiss Army knife. She turns and she tries to defend herself. And this is where the defensive wounds come in. And he keeps stabbing her over and over and over 55 times. And in this process, they're knocking over the furniture. She's trying to get away from him. She's trying to live. She's trying to survive. But she doesn't. And then he changes his clothes. He throws that vest and that gray shirt in a completely dark basement, hoping that no one will find it. He ditches those white shorts and those KD8 shoes. Don't know where. Can't find them. He had 2 hours to do it. Then he tries to clean up. He's putting that rubbing alcohol everywhere in that front room. Detective Huckey told you, distinct smell. Then he goes in the bathroom and tries to clean himself up. That blood's everywhere in the sink. Her blood that he's washing off of him, washing off of his own hands, washing off of his own arms. And then he tries to clean up that knife. He tries to get her blood off of that knife. And then after he does all of that, he has the audacity to start giving her CPR when the police arrive and try to blame it on 3 City of Hamilton utility workers. And the final piece of that puzzle is what the defendant gave you here on Monday morning that I've already told you. I'm responsible for what happened to her. He said it to his daughter, sitting in the back of the courtroom. Ladies and gentlemen, you're going to have 4 counts here to consider when you go back to deliberating. And the judge is going to instruct you on the law and what some of the terms are in those counts and what they're defined as. And I'm going to give you a shorter version of that here now. Can you turn it? Thank you. So I'm going to take these in reverse order. So I'm going to start with count 4 because I think it's a more logical way to look at these. Oh my gosh, how do I, I'm sorry, do it one second. I think I got it. Count 4, felonious assault. Knowingly cause or attempt to cause physical harm to Rachelle Brewsaugh by means of a deadly weapon, in this case a knife, and then it occurred on October 11th, 2022 in the city of Hamilton, Butler County, Ohio. The judge is going to instruct you that knowingly means a person acts knowingly regardless of their purpose when the person is aware that their conduct will probably cause a certain result or probably be of a certain nature. When you stab somebody 55 times, it's pretty clear that that conduct is probably going to have a certain result or be of a certain nature. I don't think there's any disputing that. And in this case, he used a knife. I submit to you, it's that Swiss Army knife. And clearly, as we've stated over and over, and you've heard, this happened on October 11th, 2022 at 1270 Parish, the city of Hamilton, Butler County, Ohio. Count 3, felonious assault again, serious physical harm. I just read to you before what knowingly means. It's the same argument. Cause serious physical harm to Rachelle Brewsaugh. Ladies and gentlemen, there is nothing more serious than death. That is the worst kind of serious physical harm. And again, October 11th, 2022. Count 2, murder. Caused the death of Rachelle Brewsaugh as a proximate result of committing the offense of felonious assault. We just went through those felonious assault counts. 55 stabs. She's killed. She's laying dead in that floor in the front room at 1270 Parish. Count 1, murder. purposely caused the death of Rachelle Brewsaugh, again on October 11th of 2022. The judge is going to tell you that a person acts purposely when it's his specific intention to cause a certain result. Ladies and gentlemen, there is no other result that can be intended from stabbing someone 55 times. There's no mistaking that. Clearly it killed her. It hit her internal organs. It hit her liver. Pierced her heart. Pierced her lungs. That's a certain result. You know what you're doing. So you've sat here a week and listened to all of this. You've received all the pieces of that puzzle. You put them together. It's very clear. That puzzle is the defendant, Toby Madden. Find him guilty on all 4 counts. Thank you.
Thank you, Mr. Hahn. Mr. Wilder?
Thank you. The first thing I want to do is thank you. We've taken 5 days away from you. Some of you may be happy that you're away from work, but we've taken you away for 5 days to consider this case. And as we can all agree, couldn't get much more serious with allegations than what we've been here all week for. Don't think that it doesn't go unnoticed that we don't see you paying attention, listening to the witnesses. Didn't appear that anyone fell asleep. We appreciate that you did that because a serious case involves serious jurors, and you were up to the task. Before I start with making my comments and arguments about the evidence, when you cause the death of someone, the state of Ohio has to determine, well, what's your level of culpability, meaning something, was it negligent, was it reckless, was it intentional, was it purpose? For example, you run a stop sign driving and you hit a pedestrian and they die. Something like that could be negligent. You're coming here to court today and you're going down the interstate 110 miles an hour and you hit a car and somebody dies. Well, you didn't mean for that to happen, but you were certainly probably reckless. You also may have a situation where you get in a car, you see somebody, and you tell yourself, I'm going to hit that person. I'm going to run them over. Then you start to get into an intentional, purposeful act. And then the top of the top, which is not here, but you decide, I know when, where somebody's going to be, I'm going to hunt them down, and I want them to die. And that gets into something much more higher than what we're here today for. My point with this is you can't just focus on the fact that someone is dead. You have to look at their level of culpability. Because this level of culpability is in these elements. The judge will give you the instructions on this to make that determination. Toby and Rachelle, they're together 28 years. Some of you jurors may not even be 28 years old, or just a little over than that. That's how long they were together. They're together Michaela's entire life. They're both grandparents together. Their relationship, you heard from witnesses, it's up, it's down, it's hot, it's cold, it's rocky. We even heard about some physical confrontations. Not every relationship is perfect, and certainly this one was not either. You also heard evidence that Toby believed that Rachelle was cheating on him. You also know that Rachelle is trying to renovate Parish. We saw the pictures, you saw the materials, you heard from witnesses. She's trying to get what used to be apparently a drug house, people in and out. They're trying to get this together. They're trying to renovate it. And it's not something where she's doing it and she continually kicks Toby out. Toby's there almost every day. You heard evidence, you heard testimony that Toby may be involved on some level with helping this. He's there when she's trying to get the gas fixed. So I submit to you that they're both renovating this Parish Avenue. Maybe to start a different life, the new turn in the relationship, the hot and the cold, maybe now we're hitting our stride, we're back to good. Let's go to Parish and get this thing together and turn a corner. The neighbors are happy to see them. I know Miss Myers, the bank robber, she comes in, she's Toby's strange, he's a little weird, but he's over there every day. She lets him come into her house, use her phone. She's thrilled to have Rachelle and Toby there because she told you what kind of people were coming in and out of that house. Finally, she has good neighbors. And when she says neighbors, she's referring to Toby and Rachelle. Back to the culpability. All right, so Toby is charged with two different types of murder. In Ohio, there's two different statutes. The first statute that you can be charged with murder is under Section A. In order to prove that, the state has to prove beyond a reasonable doubt that Mr. Madden purposefully did this. More specifically, that Toby's specific intention was to cause the death of Rachelle. That this is what he wanted. That was his specific intention. Rachelle needs to die. The second way to prove murder in Ohio, the state is charging him in a knowingly manner. It's called felony murder. And as a result of that, you have to prove the culpability. We call it the mens rea, what someone's thinking. They have to prove that he knowingly wanted it to happen. For knowingly, state has to prove beyond a reasonable doubt that Toby was aware of his conduct will probably cause a certain result or will probably be of a certain nature. That he knows what he's doing. That she needs to die. I want her to die. I'm going to do this so she's dead. Part of count 2 involves a deadly weapon. We're going to get back to that in a second. But these, I'm assuming the Swiss Army knife, the 2-3-inch tiny Swiss Army knife, I'm assuming that's what they're alleging as the murder weapon, the one with no blood on it. We'll come back to that. So, we have these two things. We have purpose, and we have knowing. Let's think about the evidence here. You didn't hear from Toby, but the state decided to not only play, but talk about what he said here in open court. Nothing could make an attorney more nervous than when a client starts to talk. Right? This is what Mr. Madden said. The state has put this into evidence. I'm responsible for what happened to her. I didn't mean to do it. I'm so sorry. I love you. I don't want you to hate me. I don't think any witness, law enforcement, neighbor, whoever, didn't deny. Also, Toby was hysterical. He's distraught. He's crying. He can't keep it together. The detective said he was down there for 4 or 5 hours. And he didn't see the video, but he did agree with me. Mr. Madden spends almost all that time just laying on the floor, hysterical. He's given CPR to Rachelle. State even wants you to think that he's given her CPR after she's even dead. Is it someone who purposely wants someone dead? Why would you even give CPR at the beginning if you've done it? And why would you continue? If she's dead, that's what you want. You leave them alone. You walk out. You get Rachelle's car out front and leave. You walk away. You run from the police. You don't sit there and continue to give CPR to someone who's dead if that's what you want. What's the point? We're going to get to that. What about the gas service guys? Hey, we come in 8, 9 o'clock, whatever time. Rachelle's got the big dog. We're there to do a job. Nothing seems unusual to us. Rachelle doesn't seem worried, upset, afraid. Heck, it sounds like Toby's asleep in the chair. No worry in the world. Is right there in the chair, maybe woke up and said, "What's up?" We don't hear from them gas workers there's any tension. I mean, I know they're not there to be Dr. Phil or somebody like that, but think about it. If you're a serviceman going in and out of people's houses, you see something wrong, you may walk out and think, something weird about that. I'm here to do the gas, but in your mind, you would remember that. Because they certainly remember the dog, right? The big dog. 2 years, and they still remember that. If they just saw something unusual, they would have told us. Here's my point with that. Got Toby asleep, everything calm. Then, 2, 3 hours later, if the state would please pull up 39. Just so you know, only one computer's connected, so that's sometimes me. 2, 3 hours later, here's what we got. The gas guys went in there and said nothing wrong, didn't see anything wrong. She seemed fine. He was asleep. I didn't see anything on the floor. Police come in. Here's what they see. Also, please pull up 40. Then they see Rachelle there. Broken lamp. Furniture on the floor. What do they also find? Please pull up 64. Blood on the windowsill. 67, please. Blood splatter on the wall. So we go from gas workers saying, no problems, everything seemed fine. 2 hours later, we got this. So what happened? Well, what about motive? Why would he want her dead? The state doesn't have to prove motive. They'll get up here in a minute and probably tell you that. You'll be instructed that they don't have to prove motive. It's a good thing they don't have to prove it, because guess what? What is the motive? Where is it? What did we hear? Why would he want to stab her? I mean, these people are together this long, and if you believe Miss Cook's story, that Toby Madden continually said he was going to cut her head off and put her head in the lap of grandma, similar to something out of The Godfather. Well, if you do, I'll just say whatever. Why is that happening? Where's his motive to want to do that? Everything is fine, not even 2 hours before. They're working together on this house, 28 years together. They got grandkids. And remember, we go back to the mental culpability. It's not that she's dead. It's not that her death is caused. It's the mindset. Right? Because in the scenario where I run a stop sign and I run someone over and kill them, that's a homicide. Someone's dead. And then when I get in my car and I go, I know where you're going to be. You're going to be at Starbucks at 9 o'clock. I'm going to hunch down, find you, run you over. Those are both homicides. Those are both scenarios where someone is dead. I've caused the death in both of those. The problem for the state is that you've charged him with the highest level, that this is what he wanted, that Toby Madden wanted her dead. If he's continually, again, if you believe Ms. Cook, that he walks around saying, I'm going to cut her head off, put it in mom's lap, wouldn't something have happened before 28 years? I mean, why that day? Because something happened in those few hours after those gas workers left. Something quick happened. There had to be an argument, something, because all that furniture's on the ground. Now, I am not bringing up Toby's injuries that we're going to see here in any way to try to say that he's a victim. I'm not. If the state would please pull up 82. I am in no way trying to compare and contrast some of these, what appear to be maybe minor injuries on Toby that the police took. I am not trying to do that in any way. It is terrible what happened to her. But does this tell us a story about something that may have happened? Because the state wants you to believe Toby, after 28 years renovating, we're grandparents together, October 11th is the day Rachelle needs to die. Something happened. Furniture, Toby's injuries, while minor, something's going on. We know he thinks she's cheating. Right? People told us that. His own daughter told us that. He thought she was cheating. It's hard to imagine that October 11th was the day that Toby just decided Rachelle needs to be done. And I know I've harped on it twice, and I'll harp on it a third time. Because don't just look at the fact that there was a death caused. You have to look at the mental element. Because the state has to prove beyond a reasonable doubt every element. They have to prove that her death was caused. Absolutely. They also have to prove his mindset. Did he act with purpose? Did he know what he was doing was going to cause her death? If the state could please pull up 149. I believe that the state's claiming that this is the murder weapon. I bet there was another knife, but it wasn't even analyzed. I mean, Toby, you didn't hear any evidence that he left or anybody else coming in or out, so this is the knife they got. And if this is first of all, I submit to you, this is not a deadly weapon, because I don't know if it could inflict the injuries that some of those are. You had officers there for over 9 hours, and they went there for 2 days. And this is it. This is the deadly weapon. but it doesn't have any blood on it. It was sent for analysis. Nothing there. I mean, if you're going to stab someone 55 times to the point where intestines are coming out, and it's deep enough to touch the heart. I know I started with the liver, and then the coroner said, well, you can get to the liver like this. But then he said something like the heart is a little different. State has to prove to you that he used a deadly weapon. This is what you've been provided. I submit to you that wasn't even used because there's no evidence that it was. Or DNA or what the DNA expert talked about something being down inside this Swiss Army knife, but it wasn't blood. 55 times, intestines out, and there ain't any blood on that? You got one detective who said, I went in, it was so unbearable, the smell of alcohol. Next officer said, no, I didn't smell anything at all. Did you hear any testimony that, hey, we went and got Toby from the scene, we were interviewing him, and he smelled of alcohol? Rubbing alcohol, not like liquor, booze. Who else told you that? Nobody. If you're cleaning up the crime scene, as they've claimed, where is all the evidence of this alcohol and stuff? It's not there. And you know what that also does? It proves that he didn't purposely do this, that it wasn't his specific intention. He didn't know that's the result. People who clean up crime scenes, people who leave them, do that stuff. Those are the people who want something done, and they're going to take care of it after. People who want others dead don't stick around to give CPR, and don't give it to the point where someone is dead. Ladies and gentlemen, the state of Ohio can't meet these elements. You have to stay focused on the mental element of this. She's dead. It's horrific. It should not have happened, but it did. The element you need to focus on is the mental part of this, because they want to prove to you, and they have to prove to you, that this is what he wanted. And that's simply not the case. Thank you.
Thank you, Mr. Wilder. State rebuttal?
Yes, Your Honor, thank you.
Yeah. Go ahead and do that. Go ahead, done. I'm not going to show them the stick.
May it please this honorable court. Good morning, ladies and gentlemen. 55 stab wounds. 55 stab wounds. To the head, the arms, the hands, chest, abdomen, liver, lungs, heart. 55 stab wounds. Ladies and gentlemen, this is personal. This is personal. And again, we heard there was some cross-examination about wasn't there a break-in, 5 days prior? This isn't some druggie coming in and doing this. This is a personal attack that happened. 55 stab wounds. Nobody else came in and did this. It was this defendant right there. Now, the city workers, they had nothing to do with this. It was this defendant. And I submit to you, ladies and gentlemen, this defendant committed purposeful conduct and knowing conduct. And why is that? What do we learn from Catherine Daly from DCI? She told you that this defendant's clothing, the vest that we saw him wearing at Kroger, the gray shirt we saw him wearing at Kroger. What did that have on it? It had Rachelle's blood from those 55 stab wounds. Her blood is on his clothing. And what did he do with it? He hid it. He put it in the basement, in the dark basement. This isn't some accident or anything like that. If he didn't mean to do something, why is he covering it up? Why is he trying to hide his clothing? Where are the shorts? 55 stab wounds. What else does this defendant do? There's nobody else that's in this house. Nobody's coming in. Nobody's getting past Rachelle. Nobody's getting past the dog, putting his clothing on, stabbing her, and then cleaning up afterwards and hiding the clothing. That's not happening. It's this defendant's conduct. What else does this defendant do? He cleans up in the bathroom. Her blood is in the bathroom sink. If you didn't mean to do something, why are you hiding your clothing? Why are you cleaning up afterwards to make it look like it didn't happen there? Why do that? It is purposeful conduct when you stab somebody 55 times. The head, the chest, the arms, the hands. What's the phrase, death by 1,000 cuts? This defendant sure tried. 55 is a lot, ladies and gentlemen. And Rachelle's screams were so loud. The 74-year-old bank robber that was next door on her front porch heard Rachelle screaming for her life. Obviously, you guys are fact finders and truth seekers. You heard her testimony from this witness stand. Is it reasonable to believe that that blood-curdling scream that she heard is coming from Michaela's mother? Your reason and common sense tells you that, ladies and gentlemen. This isn't some accidental conduct by this defendant. He wanted Rachelle to die. What else did this defendant do? In his clothing, the green vest, the gray shirt, washed up the blood. And again, the 12 of you are the fact finders and truth seekers in this case. And I'm not going to put any photos up here on the screen, but look at those stab wounds to Rachelle. Look at the cutting in the clothing of not only Rachelle, but of this defendant. Doesn't it kind of look like that knife that we just had up there, that Swiss Army knife? Doesn't it kind of look like that knife? And where did we find that knife? It wasn't laying there in the middle of the crime scene. We put it in Rachelle's purse, the book bag. If this was some accidental conduct or he didn't mean to do something, why go through all these measures, these methods, to try and hide what it is that happened, to hide the clothing, to wash up the blood, to hide the murder weapon? Why take the time to take the bloody clothing downstairs in the dark? Why? He wanted Rachelle to die on October 11th. Whatever it is that happened, was it something over, I think it was Brian Short, I believe you heard from him on Tuesday morning. He told you, I'm explaining to Rachelle what it is that's going on, what it is that happened, why we couldn't work on the gas lines. And Brian Short, from this witness stand right here, he told you, as I'm explaining this to Rachelle, he's looking right at this defendant right here. giving him the look. And you're right, Mr. Wilder is correct. I'm going to tell you, I don't have to prove what the motive is in this case. But 55 stab wounds is pretty darn personal. Something happened. "55 stab wounds. How do you not mean to do it when you have 55 stab wounds? One stab wound, maybe you could say you didn't mean to do it. Probably not, but again, maybe. But 55 to the head, the chest, the abdomen, the arms, the hands. Come on, ladies and gentlemen. That is not reasonable. It's not reasonable at all. Why give CPR? Why give chest compressions? Again, defendant is keeping up the ruse and trying to get people to believe that he's not the one hiding clothing, washing up the blood, putting the murder weapon back in her purse. Detective Katie Johnson told you when I get there, this woman's obviously dead. The intestines are hanging out of her body. She's pale. He's trying to keep up the ruse that he had nothing to do with this. Defendant told you from his mouth. State's Exhibit 250. You want a chance to play it back in the jury room? He told his own daughter, the daughter that him and Rachelle have together. This defendant said, "I'm responsible for what happened to her. I'm responsible for what happened to her." What happened to her was 55 stab wounds. And that's what he's responsible for, ladies and gentlemen. Ladies and gentlemen, I do want to thank each and every one of you for your time and attention. Mr. Wilder, I'm going to say some of the same things that he said. I've been paying attention to each and every one of you. As you're seated over there, you've been paying attention, you've been taking notes, you've been listening to the testimony. Thank you for your patience with me through some of my computer issues that I had. 55 times. Each time this defendant stabbed Rachelle, she got closer to her death. As Dr. Updegrove told you through those photographs. Each stab wound brought her closer to death. She got butchered in the home that she was renovating. And I ask that you hold this defendant responsible for killing her. Thank you.
Ladies and gentlemen, I want to say that State Exhibit
Jurors, I'm going to ask you to return to the jury room.
State Exhibit 66 is a stick in there. And I also, if you look at the video of them questioning me down at the police station, if you look at it, they asked me, how did the blood get in the sink? I told them that there was blood on my face after I was doing CPR, and I told them that I went to the sink.
Recess at this time.
Look at State Exhibit number 66. Ask for it back there and see. There's a stick right there. They won't. There's plenty of things they won't bring to you. Ask for it. Right?
You can get that. Okay, now we're
Right.
Okay, so
I look, you're not commenting.
the court is not going to tolerate. Let me get back on from
You're not, listen,
All right,
what
we're
you're
going
not
to
going
move
to
to
do
the
is I'm not
defendant to
going to
the
sit
upstairs
here
room
and
location to
allow
take a
you
recess.
to...
Thank you.
This is what you did the last time went on.
Exhibit 66. Exhibit 66. I think you said it was a stick.
You want to come running down the hall this time? You got something to say?
Mr.
Okay, it's going to take us about 10 minutes to get situated for the defendant to appear remotely. I do have copies of the final instructions for counsel. We'll share those at this time. And the court will need to read an instruction to the jurors as to why he is not in the room. I'm going to take that straight out of the Ohio Jury Instructions Manual. And, once we are ready to go upstairs, we will proceed. But if counsel wants to review that instruction, you're welcome to do so. It's 2 OJI CR 4303, and if there are any is any discussion you'd like to have about that prior to me giving it, you're welcome to let me know. Okay, so we can go off the record. Thank you.
Thank you, Judge. Thank you.
Is that the copy
Yes.
press?
Well, let's take that moment to see if you guys have hit the like button or not. For those out there that are not in chat, if you have not hit the like button and you're watching that, we're at 147 likes. Let's see if we can get up to 150 just for that alone, just for that outburst. So again, Exhibit 66, I think he said something about a stick. I think I heard him say something about stick. Yeah, that defense lawyer can move. Yeah. Well, it's pretty amazing. He has his outbursts, but he doesn't take it to the next level. Like, was it Diabra Redden? Remember, he was the judge jumper out in Las Vegas. Who's oh my gosh, who's Letitia? No, who's the one that attacks her who cut off Shabiznes? Yeah, Taylor, right? Taylor Shabiznes attacking her lawyers. So at least he doesn't take it to that level. But 153 likes, fantastic, you guys. Thank you so much for getting us over 150. Yeah, Debbie, it's this one was a very interesting trial. That's why since we're in between live trials and we're trying to rebuild our library of trials that we watched in the past, we thought this would be a good one. And it's what's not to like, Gordon? Exactly. Blondie with the expression, yep, I know, I hear you. Elle, you need to rewind that part? Should we rewind it? Let's watch it together. Why not? We've got time. We've got a few minutes. Let's watch that. Let's watch that again. Let's watch that again.
This defendant responsible for killing her. Thank you.
Ladies and gentlemen, I want to say that State Exhibit
Jurors, I'm going to ask you to return to the jury room.
State Exhibit 66 is a stick in there. And I also, if you look at the video of them questioning me down at the police station, if you look at it, they asked me, how did the blood get in the sink? I told them that there was blood on my face after I was doing CPR, and I told them that I went to the sink.
Recess at this time.
Look at State Exhibit number 66. Ask for it back there and see. There's a stick right there. They won't. There's plenty of things they won't bring to you. Ask for it. Right?
You can get that. Okay, now we're right. Okay, so
I look, you're not commenting.
the court is not going to tolerate. Let me get back on.
You're not, listen,
All right,
what
we're
you're
going
not
to
going
move
to
to
do
the
is I'm not
defendant to
going to
the
sit
upstairs
here
remote
and
location to
allow
take a
you to
recess.
vote.
Thank you.
This is what you did the last time went on.
So, yeah, I guess because he has that shock vest on, he knows better.
You'll come running down the hall this time? You got something to say?
Oh, man, you got something to say? Off he goes. All right, that was worth watching again. Yeah,
Okay,
Daryl Brooks or
It's going to take us
Darrell.
about 10 minutes to get situated for the defendant
Darrell
to appear
Brooks was
remotely.
just,
I do have copies of the final instructions for counsel. We'll share those at this time. And the court will need to read an instruction to the jurors as to why he is not in the room. I'm going to take that straight out of the Ohio Jury Instructions Manual. And once we are ready to go upstairs, we will proceed. But if
He's going to be out of the courtroom. I don't think he comes back.
Heard in
in.
State versus Madden, the jurors are not present. Mr. Burris, Mr. Hahn, and Detective Horton are present on behalf of the state of Ohio, and and Mr. Wilder is present on behalf of Mr. Madden. For the record, Mr. Madden has been taken to another location in the building. He is able to view these proceedings remotely and hear what is going on in the courtroom, and we are able to view him as well, but his voice will not be able to come through our system, so we will be able to proceed without further disruption. So I apologize to counsel and to those in the gallery for the disruption, and if there's nothing else from the state, we'll bring in the jurors and proceed.
I believe that's correct, Your Honor. Yes.
Mr. Wilder?
Nothing from the defense. Thank you.
Okay, please bring in the jury. Please be seated. Are there any violations of the court's recess instructions that anyone needs to report? Okay. Ladies and gentlemen, the defendant has a right to be in the courtroom at every stage of the trial unless the defendant's conduct is so disruptive that the trial cannot reasonably be conducted with the defendant's continued physical presence. The court has concluded, due to the defendant's conduct, that the trial will proceed in the defendant's absence by remote contemporaneous video as if the defendant were present. You may not consider the defendant's conduct or absence for any purpose, nor are you to consider the court's response to the conduct. The statements the defendant was making to you are not evidence. They were not made under oath or on the witness stand and may not be considered by you for any purpose. You must decide this case solely on the evidence presented. Now, ladies and gentlemen, you have heard the evidence and arguments of counsel. The court and the jury have separate functions. You decide the disputed facts, and the court provides the instructions of law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You are not permitted to change the law, nor apply your own idea of what the law should be. The instructions I am about to give you will be lengthy and involved. The nature of the case requires these extensive instructions of law, which will include legal concepts and definitions which may be unfamiliar to you. Please listen carefully. A criminal case begins with the filing of an indictment. The indictment informs the defendant that he has been charged with an offense. The fact that an indictment was filed may not be considered by you for any purpose. The defendant's plea of not guilty is a denial of all charges and puts in issue all of the essential elements of the offense. The defendant is presumed to be innocent until his guilt has been established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense charged in the indictment. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. If after a full and impartial consideration of all the evidence, you are firmly convinced of the truth of the charge, the state has proved its case beyond a reasonable doubt. If you are not firmly convinced of the truth of the charge, you must find the defendant not guilty. What is the evidence? Evidence is all the testimony received from the witness stand and the exhibits admitted during the trial. Evidence may be direct or circumstantial or both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which he or she testifies. It also includes the exhibits admitted into evidence during the trial. Evidence may also be used to prove a fact by inference. This is referred to as circumstantial evidence. Circumstantial evidence is the proof of facts by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. To infer or to make an inference is to reach a reasonable conclusion of fact, which you may make, but are not required to make, from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. Direct evidence and circumstantial evidence are of equal weight. By way of example of circumstantial evidence, if the question of a fact in a given case is whether or not Johnny ate the cherry pie, testimony by a witness that he saw Johnny put the pie in his mouth and eat it would be direct evidence of such fact. However, if a witness testifies that he arrived in the kitchen only to see Johnny standing there with the empty pie tin in his hand and cherry pie on his face, that would be circumstantial evidence of the fact that Johnny ate the pie. The evidence does not include the indictment or the opening statements or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. Statements or answers that were stricken by the court or which you were instructed to disregard are not evidence and must be treated by you as though you never heard them. You must not speculate as to why the court sustained an objection to any question or what the answer to that question might have been. You must not draw any inference from or speculate on the truth of any suggestion included in a question that was not answered. You are the sole judges of the facts and the weight of the evidence. To weigh the evidence, you must consider the credibility, that is, the believability of the witnesses. You will use the test of truthfulness, which you use in your daily lives. There are several tests of truthfulness, one of which is the bias or interest, if any, of a witness. That is, if a witness has a personal, philosophical, or financial interest in the outcome of a case, that fact can be considered in determining the weight to be given to that witness's testimony. Other tests of truthfulness, which you will consider, include the appearance of each witness upon the stand, his or her manner of testifying, the intelligence of the witness, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which he or she testified, his or her accuracy of memory, frankness or lack of it, together with all the facts and circumstances surrounding the testimony. Apply these tests and assign the weight you deem proper to the testimony of each witness. You are not required to believe the testimony of any witness simply because he or she was under an oath. You may believe or disbelieve all or part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of that issue. Rather, the final test in judging evidence should be the force and the weight of the evidence, regardless of the number of witnesses on each side of an issue. The testimony of one witness, believed by you, is sufficient to prove any fact. If there are discrepancies in a witness's testimony or between any witness's testimony and the testimony of other witnesses, this does not necessarily mean that you should disbelieve the witness, as people commonly forget facts or recollect them differently after the passage of time. You are all certainly aware that two persons who are witnesses to an event may see or hear it differently. In considering a discrepancy in a witness's testimony, you should consider whether that discrepancy concerns an important fact or a trivial one. Should you in the course of your deliberations conclude that any witness has intentionally testified falsely to a material fact, you are free to disregard all of that witness's testimony on the principle that one who testifies falsely as to one material fact may also testify falsely as to other facts. You are not required, however, in all circumstances to consider such a witness unworthy of belief. You may accept as much of the testimony of that witness as you wish to believe to be true and reject only that part which you conclude is false. Generally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you to arrive at a just verdict. Questions may have been asked in which an expert witness was permitted to assume that certain facts were true and to give an opinion based upon such assumption. You must determine whether the assumed facts upon which the expert based his or her opinion are true. If any assumed fact was not established, you will determine its effect upon the opinion of the expert. However, as with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the expert. In determining its weight, you may take into consideration his or her skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to the testimony. If you find the state has proved beyond a reasonable doubt all of the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be guilty as to such offense or offenses according to your findings as to the defendant. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be not guilty as to such offense or offenses according to your findings as to the defendant. The charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your findings as to each count, uninfluenced by your verdict as to the other counts. The defendant may be found guilty or not guilty of any one or all of the offenses charged. It is not necessary that the defendant take the witness stand in his own defense. The defendant has a constitutional right not to testify, and he must not be prejudiced in any way for exercising that constitutional right. The fact that the defendant did not testify must not be discussed in your deliberations, and it must not be considered for any purpose. Now, under count 1 of the indictment, the defendant is charged with murder. And before you can find the defendant guilty of murder, you must first find beyond a reasonable doubt that on or about October the 11th of 2022 in Butler County, Ohio, the defendant purposely caused the death of Rachelle Brewsaugh. Purpose to cause the death of another is an essential element of the crime of murder. A person acts purposely when it is his or her specific intention to cause a certain result. It must be established in this case that at the time in question, there was present in the mind of the defendant a specific intention to cause the death of Rachelle Brewsaugh. Cause is an essential element of the offense of murder. Cause is an act which in a natural and continuous sequence directly produces the death and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act. The defendant is also responsible for the natural and foreseeable consequences that follow in the ordinary course of events from the act. In count 1, the essential elements of the offense of murder are 1, that the defendant did, 2, purposely, 3, cause another's death, specifically that of Rachelle Brewsaugh, and 4, in Butler County, Ohio. If you find the state of Ohio proved beyond a reasonable doubt all of the essential elements of the offense of murder, your verdict must be guilty. If you find the state of Ohio failed to prove beyond a reasonable doubt any one of the essential elements of murder, then you must find the defendant not guilty. Under count 2 of the indictment, the defendant is charged with murder. Before you can find the defendant guilty of murder, you must first find beyond a reasonable doubt that on or about October the 11th of 2022 in Butler County, Ohio, the defendant caused the death of Rachelle Brewsaugh as a proximate result of committing the offense known as felonious assault. The court has previously defined the term of causation for you. Now, before you can find the defendant was committing the offense known as felonious assault, you must find beyond a reasonable doubt that the defendant, on or about October the 11th of 2022 in Butler County, Ohio, knowingly caused serious physical harm to Rachelle Brewsaugh or caused or attempted to cause physical harm to Rachelle Brewsaugh by means of a deadly weapon. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or will probably be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. When knowledge of the existence of a particular fact is an element of an offense, such knowledge is established if a person subjectively believes that there is a high probability of its existence and fails to make inquiry or acts with a conscious purpose to avoid learning the fact. Because you cannot look into the mind of another, knowledge is determined from all of the facts and circumstances and evidence. You will determine from the facts and circumstances and evidence whether there existed at the time in the mind of the defendant an awareness of the probability that his conduct would result in him causing or attempting to cause physical harm to Rachelle Brewsaugh by means of a deadly weapon or causing serious physical harm to Rachelle Brewsaugh. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon knowledge. The concept of causation has previously been defined for you. Now, an attempt occurs when a person knowingly engages in conduct that, if successful, would result in physical harm. Physical harm means any injury, illness, or other physiological impairment, regardless of its gravity or duration. Deadly weapon means any instrument, device, or thing capable of inflicting death and designed or specifically adapted for use as a weapon or possessed, carried, or used as a weapon. A deadly weapon is an instrument, device, or thing that has two characteristics. The first characteristic is that it is capable of inflicting or causing death. The second characteristic is in the alternative. Either the instrument, device, or thing was designed or specifically adapted for use as a weapon, such as a gun, billy club, or brass knuckles, or it was possessed, carried, or used in this case as a weapon. These are questions of fact for you to decide. Serious physical harm to persons means any of the following: any harm that carries a substantial risk of death, any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity, any physical harm that involves some permanent disfigurement or that involves some temporary serious disfigurement, any physical harm that involves acute pain of such duration as to result in substantial suffering or that involves any degree of prolonged or intractable pain. In count 2, the essential elements of the offense of murder are 1, that the defendant did, 2, cause, 3, another's death, specifically that of Rachelle Brewsaugh, 4, as a proximate result of the defendant's committing, 5, the offense of felonious assault, and 6, in Butler County, Ohio. If you find that the state of Ohio proved beyond a reasonable doubt all of the essential elements of the offense of murder, your verdict must be guilty. If you find that the state of Ohio failed to prove beyond a reasonable doubt any one of the essential elements of murder, then you must find the defendant not guilty. Under count 3 of the indictment, the defendant is charged with felonious assault. Before you can find the defendant guilty of felonious assault, you must first find beyond a reasonable doubt that on or about October the 11th of 2022 in Butler County, Ohio, the defendant knowingly caused serious physical harm to Rachelle Brewsaugh. The court previously defined all terms necessary for you to decide count 3. Those definitions apply here as well. In count 3, the essential elements of the offense of felonious assault are 1, that the defendant did, 2, knowingly, 3, cause, 4, serious physical harm to Rachelle Brewsaugh, 5, in Butler County, Ohio. If you find the state of Ohio proved beyond a reasonable doubt all of the essential elements of the offense of felonious assault in count 3, your verdict must be guilty. If you find the state of Ohio failed to prove beyond a reasonable doubt any one of the essential elements of felonious assault in count 3, then you must find the defendant not guilty. Under count 4 of the indictment, the defendant is charged with felonious assault. Before you can find the defendant guilty of felonious assault, you must first find beyond a reasonable doubt that on or about October the 11th of 2022 in Butler County, Ohio, the defendant knowingly caused or attempted to cause physical harm to Rachelle Brewsaugh by means of a deadly weapon. The court previously defined all terms necessary for you to decide count 4. Those definitions apply here as well. In count 4, the essential elements of the offense of felonious assault are 1, that the defendant did, 2, knowingly, 3, cause or attempt to cause, 4, physical harm to Rachelle Brewsaugh by means of a deadly weapon, 5, in Butler County, Ohio. If you find the state of Ohio proved beyond a reasonable doubt all of the essential elements of the offense of felonious assault in count 4, your verdict must be guilty. If you find that the state of Ohio failed to prove beyond a reasonable doubt any one of the essential elements of felonious assault in count 4, then you must find the defendant not guilty. You may not discuss or consider the subject of punishment. Your duty is confined to the determination of the guilt or innocence of the defendant and to the determination of any additional findings that may be submitted to you. In the event you find the defendant guilty, the duty of determining punishment is placed by law upon the court. You must not be influenced by any consideration of bias, sympathy, or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence. Make your finding with intelligence and impartiality and without bias, sympathy, or prejudice so that the state of Ohio and the defendant will feel that the case was fairly and impartially tried. If during the course of the trial the court said or did anything that you consider an indication on the court's views on the facts, you are instructed to disregard it. You will be provided with a copy of these instructions. If during your deliberations you are in doubt about a portion of the instructions, you may request clarification. The foreperson must put your question in writing, stating specifically what is requested, and that communication must be delivered to the bailiff. Your initial conduct upon entering the jury room is a matter of importance. It is not wise to express immediately a determination to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position, even if you later decide you are wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender honest opinions in order to be congenial or to reach a verdict solely because of the opinion of other jurors. Now, you have been permitted but not required to take notes during the trial. You will recall that I instructed you prior to distributing the notepads that the decision to take notes was a purely personal one for each juror, based upon individual habit and preference. As I said at the beginning of the trial, note-taking does not make a juror necessarily a more careful auditor of the testimony or a better observer of a witness's demeanor. Obviously, the notes of the individual jurors are not in any way to be considered verbatim records of testimony. It cannot be overemphasized that an individual juror's notes are just memory aids for that particular juror. Now, our alternate jurors, you were selected to serve in the event of any misfortune to a member of the panel. It appears that everyone is well and able to continue, so fortunately your services will not be required anymore at this point, and it will not be necessary for you to serve further. You are not to discuss this case or tell anyone how you would have voted until after this jury has returned its verdict. You will be excused when I leave the bench, and I would ask you to please leave your contact information with Mr. Halcomb in the event that one of the jurors is unable to continue, because you would be called back in and would then need to serve. So again, it is important that you not discuss this case until the jurors have rendered their verdict. On behalf of the public and the parties, I wish to express my appreciation for your services in performing this most important function. Now, the first order of business in the jury room is going to be to select a foreperson, and the court will place in your possession the exhibits and the verdict forms. The foreperson will retain possession of these materials and return them to the courtroom. The foreperson will see that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. Until your verdict is announced in open court, you are not to disclose the status of your deliberations or the nature of your verdict to anyone else. Now, the verdict forms that I am talking about will look like this. There will be 4 of them. Each one has the case caption, and it will say, "We, the jury, being duly impaneled, find the defendant, Toby Madden," and you're instructed to check 1. Not guilty or guilty, and there's 1 for each of the offense. 1 for count 1 murder, 2 for count. The second verdict form is for the second count of murder. The third verdict form is for count 3 felonious assault, and the fourth form for count 4 felonious assault. And you'll see that there are 12 lines. In order to reach a verdict, each of you must sign in ink. After you have reached a verdict and you've signed those forms in ink, you will knock on the door and let Mr. Halcomb know that you have reached a verdict, and then we will return you to the courtroom. Okay, at this time I'd like to invite counsel to sidebar.
All right, so he's not in court anymore. They can't show him, so he's not in court. I don't know if he's going to come in for the verdict or not. Yeah, camera's looking for him, but he's not there anymore. The empty chair, the lonely chair. That's where Toby should be sitting.
At this time, you may now retire and begin your deliberations. Okay, the jurors have been excused from the courtroom. If you kindly be seated, I do want to take up another issue. We have the issue of the repeat violent offender specification, and that is obviously something that if the jurors find the defendant guilty, the court will decide if that has been proven. Is there any evidence that the state wishes to introduce in the event that the court is required to make that finding?
So, Your Honor, back on January 11th of 2024, I did do a notice of intent to use a certified prior conviction as proof of the prior. I believe it was pursuant to 2941.149. So I have one exhibit.
There's a sticker.
I do have a certified prior conviction. I'm just looking for a state's exhibit sticker.
I may have left it.
We can.
Ms. Allen has it.
Do you have an exhibit sticker they can use?
Thank you, Your Honor.
I believe defense counsel has seen this.
Yeah, Judge, I've received this in discovery and have prior notice of it, and there's no objection to that. We would stipulate to the document as presented.
Thank you.
So would the court like me to mark that? I think our next exhibit is 251, but I know this does not go back to the jury, so I don't know if we want to mark it as...
Well, let's mark it as 251, but we'll talk about how we should handle the exhibits because you're correct, Mr. Burris, that exhibit should not be before the jury. In fact, I'll just take possession of it at the bench, and we'll make sure that it stays out of the way from you. Yes. And I will consider this, if it's appropriate to do so, after the jury's verdict.
Yes, Your Honor.
Okay. So we do have a number of exhibits. I think we've talked about them quite a bit, but I would ask that counsel stay when we go off the record to make sure all the appropriate exhibits are going back to the jury. When you've collected them and agree that those are the appropriate exhibits, if you'd provide those to Mr. Halcomb, and then Mr. Halcomb, if you'd take those in for the jurors. Except in anything that would be considered a weapon. If they wish to see that, they can ask Mr. Halcomb, and if it's okay with the parties, he will take that into them, stay in there while they look at it, and instruct them not to discuss anything while he's in the room. Is that okay with everybody?
Yes.
Yes, Your Honor.
Okay. Anything else that we need to take up before we recess?
I don't think so, Judge.
Okay.
No, Judge, I have my card, my number, in order to contact me when and if there is a verdict or a question is on the area. And I would ask the deputies to keep Mr. Madden. I would like to at least talk to him before he's sent away. Other than that, I have nothing else, Judge.
All right. So we'll take, you can provide that to Mr. Halcomb, and just be, all the attorneys be ready to be available pretty readily in case there is a question or we have a verdict, so that we can proceed as efficiently as possible. Okay, so we will go ahead and go off the record.
All right. I'm not going to do a verdict clock, obviously, because we can fast forward, but 2:30 to 3:30 is 1 hour. So 3:30 to 4. Oh, so about, what's that, about an hour and a half, and they come back. So about an hour and a half, they come back. Thank you, Debbie. Appreciate that. Thank you, Ladybug's mom. Pippi, you got a gifted membership. Awesome.
Down here. Give you now.
Okay, thank you. Okay, please be seated. We're back on the record in State versus Madden, CR 22121675. Mr. Burris and Mr. Hahn are present on behalf of the state of Ohio, and Mr. Wilder is present on behalf of Mr. Madden. Mr. Madden is appearing remotely at another location in this building, and he is able to hear these proceedings. Okay, so before I've been advised that the jury has a verdict. However, some concerns were brought to my attention during the recess that I'd like to address at this time, and I'd like to ask Sergeant Owens to please take the witness stand. Okay, Sergeant, would you please state your name?
Sergeant Jason Owens.
And what is your occupation, sir?
I'm a sergeant with the Butler County Sheriff's Office.
And what are your present duties?
I'm the supervisor over court security.
And Sergeant, in your capacity, did you have the opportunity to go to the remote location where Mr. Madden is viewing these proceedings?
Yes, I did.
And at any point while you were present with Mr. Madden, did he make any statements that caused you concern about his return to this courtroom?
Yes, he advised his attorney that if he were not wearing restraints, that his attorney was lucky that he was currently wearing restraints, implying that he would inflict physical harm if he were not.
And did Mr. Madden advise in your presence whether he even wanted to return to this courtroom?
He advised my personnel that he did not wish to return.
All right, very well. Anything on behalf of the state?
No, Your Honor, thank you.
Okay, Mr. Wilder, any questions that you have?
No.
Okay, thank you, Sergeant. You may step down. In light of the Sergeant's testimony, I'm going to continue to have Mr. Madden participate in the proceedings outside of this courtroom.
Yes, Your Honor.
Okay. All right. So I understand the jury has reached a verdict, and we are waiting on the state's representative.
You should be here momentarily.
Okay. Well, we'll go off the record for just a moment.
So he told the lawyer, his lawyer, it's a good thing I'm restrained. It's a good thing I'm being restrained. Otherwise, yep, he would have attacked him. Oh, Toby. All right. Let's fast forward a little bit here. And we're waiting for the state to come. All right.
In at this time.
Here we go.
Please be seated. Okay, ladies and gentlemen, I understand that you have reached a verdict in this case. Is that correct?
Yes.
Okay, and who is our foreperson? Okay, would you please return the verdict forms to Mr. Halcomb? Verdict form number 1. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of murder as charged in the indictment. The verdict form is signed in ink by all 12 jurors. Verdict form 2. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of murder as charged in the indictment. The verdict form is signed in ink by all 12 jurors. Verdict form 3. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of felonious assault as charged in the indictment. The verdict form is signed in ink by all 12 jurors. And finally, verdict form 4. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of felonious assault as charged in the indictment. And the verdict form is signed in ink by all 12 jurors. Okay. Does the state of Ohio wish to have the jury polled?
No, Your Honor, thank you.
On behalf of the defendant, do you wish to have the jury polled, Mr. Wilder?
No, thank you.
Okay. Okay, ladies and gentlemen, I want to thank you for your attention in this matter, and I appreciate your patience with us during some of the breaks that we had to have, and the concentration that you had throughout these proceedings. And on behalf of the public, I want to express my sincere appreciation for your services in performing this most important function. The judicial system, as we know it in the United States, is the finest in the world, and it is so very important in preserving the property and liberty and the rights of citizens that you are willing to agree to serve as jurors in this case. By your being here and participating, you are helping to guarantee the continued existence of law and social order in our society. So you have my thanks. And I'd also like to thank the attorneys in this matter for their professionalism. I have had you under an order that you could not speak about this case. Now that you have rendered your verdict, you are permitted, I will release you from that order. You are permitted to speak with anyone that you wish to about this case. You are not required to speak to anyone, but that will be your choice alone. In addition, I gave you restrictions about looking at things and investigating things. All of the orders that I gave you you're now released from those. And again, I appreciate your service very much. So you are discharged with the thanks of the court. I would ask that you return briefly to the jury room. Thank you. Okay, please be seated. And the jurors have been excused from the courtroom. Our next order of business is to take up the repeat violent offender specification. The court has reviewed State Exhibit 251. Is there anything else that the State of Ohio would like to put on the record with regards to that?
I think I put on the record I did file notice of intent to use. Certified conviction is proof of the prior conviction. That was filed on January 11th, 2024. It is a felonious assault conviction. Aggravated assault, which I don't think that part counts. It is the felonious assault is the count 4. It's in CR 88030207. So I would ask the court to find Toby Madden to be a repeat violent offender.
Okay. Any argument on that, Mr. Wilder?
No, Judge. Thank you.
All right. The court has carefully reviewed the exhibit and is going to find Mr. Madden guilty of that specification and will find that he is a repeat violent offender. Okay. The next thing that I need to ask is everyone to prepare to go forward with sentencing this afternoon.
Yes, Your Honor. Thank you.
Yes, Judge.
Okay. All right. Before we proceed to that, the conviction will require that Mr. Madden enroll as a violent offender pursuant to Ohio Revised Code 2903.41. And of course, we can continue that hearing. The basis for rebutting that, the presumption that the court place him on that registration would be that he is not the principal offender. I haven't heard any testimony that would suggest that that would be necessary. Mr. Wilder, do you oppose going forward today?
I would agree with that. No opposition to going forward. Thank you.
All right. So I'm going to give Mr. Madden some advisements, and there will be a form that I'll ask the deputies to have him sign and so that he can have a copy of it when we've concluded our hearing. Sir, you have been convicted of or pleaded guilty to a qualifying violent offender offense as defined in Ohio Revised Code Section 2903.41. If you are not sentenced to a prison term, you are required to enroll in the violent offender database personally with the sheriff of the county in which you reside 10 days after being sentenced. If you were sentenced to a prison term, you must enroll in the database personally with the sheriff of the county in which you reside 10 days after release from jail. If you are an out-of-state offender, you must enroll in the database personally with the sheriff of the county in which you reside or occupy a dwelling within 10 days of either 1, residing or occupying in a dwelling in Ohio for more than 3 consecutive days, or 2, residing in or occupying a dwelling in Ohio for an aggregate period in a calendar year of 14 or more days. You are required to provide to the sheriff certain information, including your full name and alias you use, your residence address, your social security number, any driver's license number or commercial driver's license number or state identification card number issued to you, information regarding the offense of which you were convicted or pleaded guilty, the name and address of any place where you are employed, the name and address of any school or institution of higher education you attend, the license plate number of each vehicle owned or operated by you or registered in your name, the vehicle identification number of each vehicle, and a description of each vehicle, a description of any scars, tattoos, or other distinguishing marks on your person. You are required to provide the sheriff fingerprints and palm prints. The sheriff will also obtain a photograph of you at the time of enrollment. After the date of initial enrollment, you are required to re-enroll annually. You must update and or amend any of the information described above that has changed and provide any additional information requested at the county sheriff's office within 10 days of the anniversary of the calendar date on which you were initially enrolled. If you change your residence address during the 10-year enrollment period, you shall provide written notice of that change to the sheriff with whom you most recently enrolled and to the sheriff in the county in which you intend to reside within 3 business days of the change of address. You are required to comply with all of the above described requirements for a period of 10 years unless your sentencing court determines otherwise. Failure to enroll or failure to verify residence at the specified times will result in criminal prosecution. And so that is the form, and I will go ahead and sign that at this point, and we will have Mr. Madden sign that when we have completed our hearing. Anything else on that issue from the state?
I don't believe so, Your Honor. Thank you.
Anything on behalf of the defendant?
Nothing, Judge. Thank you.
Okay. All right, then let's go ahead and discuss sentencing. First, I'd like to ask if the state of Ohio, if you believe any of these offenses are allied offenses of similar import.
The answer would be yes, Your Honor. I will.
All right. I'm going to switch gears here. Not gears. I'm just going to switch. You guys are asking for, you wish you could see him. Well, there's sentencing right after that, but then there's this. So
This is to take up the repeat violent.
All right, hold on a sec. All right, hold on a sec. Hold on. Bear with me. Okay, is this it? Okay, here it is. All right, just bear with me. You guys want to see his face? It's ridiculous how much stuff is on the screen, but we're gonna go with this. All right.
Okay, Sergeant, would you please state your name?
Sergeant Jason Owens.
And what is your occupation, sir?
I'm a sergeant with the Butler County Sheriff's Office.
And what are your present duties?
I'm the supervisor over court security.
And the sergeant, in your capacity, did you have the opportunity to go to the remote location where Mr. Madden is viewing these proceedings?
Yes, I did.
And at any point while you were present with Mr. Madden, did he make any statements that caused you concern about his return to this courtroom?
Yes, he advised his attorney that if he were not wearing restraints, that his attorney was lucky that he was currently wearing restraints, implying that he would inflict physical harm if he were not.
And did Mr. Madden advise in your presence whether he even wanted to return to this courtroom?
He advised my personnel that he did not wish to return.
All right, very well. Anything on behalf of the state?
No, Your Honor. Thank you.
Okay, Mr. Wilder, any questions that you have?
No.
Okay, thank you, Sergeant. You may step down. In light of the Sergeant's testimony, I'm going to continue to have Mr. Madden participate in the proceedings outside of this courtroom.
Yes, Your Honor.
Okay. All right. So I understand the jury has reached a verdict, and we are waiting on the state's representative.
You should be here momentarily.
Okay. Well, we'll go off the record for just a moment.
All right. Let's bring back in Eric Faddis, criminal defense attorney, who is standing by.
Four-person. Okay. Would you please return the verdict forms to Mr. Halcomb? Verdict form number 1. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of murder as charged in the indictment. The verdict form is signed in ink by all 12 jurors. Verdict form 2. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of murder as charged in the indictment. The verdict form is signed in ink by all 12 jurors. Verdict form 3. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of felonious assault as charged in the indictment. The verdict form is signed in ink by all 12 jurors. And finally, verdict form 4. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of felonious assault as charged in the indictment. And the verdict form is signed in ink by all 12 jurors. Okay. Does the state of Ohio wish to have the jury polled?
No, Your Honor, thank you.
On behalf of the defendant, do you wish to have the jury polled, Mr. Wilder?
No, thank you.
Okay. Okay, ladies and gentlemen, I want to thank you for your attention in this matter, and I appreciate your patience with us during some of the breaks that we had to have and the concentration that you had throughout these proceedings. And on behalf of the public, I want to express my sincere appreciation for your services in performing this most important function. The judicial system, as we know it in the United States, is the finest in the world, and it is so very important in preserving the property and liberty and the rights of citizens that you are willing to agree to serve as jurors in this case. By your being here and participating, you are helping to guarantee the continued existence of law and social order in our society. So you have my thanks. And I'd also like to thank the attorneys in this matter for their professionalism. I have had you under an order that you could not speak about this case. Now that you have rendered your verdict, you are permitted, I will release you from that order. You are permitted to speak with anyone that you wish to about this case. You are not required to speak to anyone, but that will be your choice alone. In addition, I gave you restrictions about looking at things and investigating things. All of the orders that I gave you you're now released from those. And again, I appreciate your service very much. So you are discharged with the thanks of the court. I would ask that you return briefly to the jury room. Thank you.
Guilty as charged for Toby Madden, and you see there, that's who everyone's hearts is with right now.
All right. I thought, hold on. Hold on a sec. I thought that there's a video of her.
This is to take up the repeat violent offender.
Hold on a sec. Just bear with me. Okay.
Together.
I think about SeaWorld in San Diego. I think about walking on the beach in Florida, the chalet in Gothenburg in February. I think about all the years, all the meals that we've had together, the Christmases, the Thanksgivings, the summers. These feelings, these emotions are
All right. It appears the audio has been turned off at this time. Any objection to that, Mr. Wilder?
To the audio being
Yes, sir.
turned on? No objection to that. I would, if I may.
You may.
Televised.
Yes, sir.
Without getting into specifics, obviously honoring the attorney-client privilege that I've held with Mr. Madden for 9 months, I can say that the specifics of the before, during, and after were never brought to my attention.
Thank you. Okay, so at this time, if there are any victims' representatives that wish to address the court will hear those statements.
I believe Michaela Madden's the first one that's going to address the court. Would you like her at the podium? Would you like her at the witness stand?
The podium's fine since it's here. like to tell me, ma'am?
I would just like to speak about my mom. That's good. Sure. Sorry, I'm a little shaky.
Take your time.
Sorry. Okay.
You're fine.
Okay. Ladies and gentlemen, I'm Michaela Madden. I'm Rachelle Brewsaugh's daughter and her only child. I wanted to make this statement because I want you to know more about my mother, Rachelle Brewsaugh. She meant so much to our family and friends. Her death has created a huge hole in our lives from which we will never recover. Rachelle, my mother, was the youngest of 4 children. She was the baby of the family. But she wasn't just a sister and a daughter. She was also an aunt, a neighbor, a friend, a member of the community, and perhaps her most important role, a mother and grandmother. Sorry. As an only child, I had the benefits of all her love and attention. She always sought to have everything I needed. She taught me to be respectful and to be well-mannered, to work hard and help others. She dedicated her life to serve. She was a nurse, and I'm following in her footsteps and hoping to become a nurse. I mentioned that my mom was also a grandmother. I'll never forget how thrilled she was to have a granddaughter. My mom relished on every moment that she had with my daughter, Layla. After I had Layla, I noticed a change in her. My mom wanted to leave her life with Toby Madden in the past. She was focused on and excited for a better life filled with love for me and her granddaughter, Layla. This has been unimaginable for me and my family. But how can I tell you who my mom was? It's impossible to express in words who my mom was and the impact this had on our family. I will miss the big things. She loved animals, especially dogs, butterflies, and dolphins. She went out of her way to help everyone. She had no enemies. She was hilarious and smart. She had an infectious laugh. And she and I were so very close. We talked about everything. She was my best friend. The one thing that got in the way and we disagreed with was Toby Madden. He was the man that my mother set out to change. Sorry. He was the man who came in and out of our lives because all he did was take. All he did was take. And he was never a loving partner for her. And he was not a good dad. I mentioned that my mom always focused on others.
All right, we need to get a break in here. We are going to pause it. We'll watch the rest of
Verdict form number 1. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of murder.
We did hear from Madden. Now we're hearing from Michaela, his daughter, addressing the judge, talking about her mother.
She took care of him through thick and thin. And Toby's only interest was to put us down. All of her accomplishments. But I have made a better impact on my life than he ever will. People ask me if I'm better or if time has healed me. I will never get over losing my mother. Her life should have never ended so tragically. My mom was a healthy 50-year-old woman. She was full of life. She was ready to move on to the next chapter in her life from Toby. A chapter full of things to do, places to go, and happiness. My life will go on. I will raise my daughter, and Toby Madden will fade into the past for me and my family. There are going to be days that Toby will wonder about us, but he will never know what is going on in our lives, and he will never get the chance to see his granddaughter grow old. Even though Toby Madden ended my sweet mother's life, she will always be with me. He's not going to end our lives, but his selfish, disgusting act of taking my mother's life will end his life as well. I know she's in heaven with God and her mother and father and sister and brother who have also passed, but I would give anything to talk to her one more time, to see her be silly and laugh with my daughter, Layla. But I know I will never, because Toby took that away from us. And I just want to say thank you to the court, thank you to the judge, thank you to the police officers, detectives, my family and friends for everything that you've done.
I'm very sorry for your loss, ma'am.
Thank you.
Is there anyone else that wishes to address the court, Mr. Burrs? Ma'am, if you could tell me your name and your relationship to the victim, please.
Hi, my name is Ginger Halcomb. I'm niece of Rachelle Brewsaugh. Our rules have changed forever. And when I say our, I mean my Aunt Rachelle, our family, and her best friends. I know they say when you're a good Christian that you'll forget what he did one day. But forgiveness or not, our family asks that Toby Madden gets life in prison without parole for brutally murdering our aunt. She has taken so much from us. He's a repetitive violent offender that has a track record to prove at the age of 52 that he has no chance of rehabilitation. Our local community itself is not safe with him unless he is behind bars the remainder of his life. Knowing that he doesn't have a chance to victimize our family anymore is the only way that we'll get time to process everything and start to heal. Over the course of 26 years, our family has been victims of so much violence because of his erratic, violent behavior. There are too many to even mention and not enough time to talk about. We have all been emotionally drained, having to wait 2 selfish years due to the delay tactics. The continual delays feel like it was his last selfish act to resort to torment our family further. Waking up every day to realize that your aunt is gone forever, that's not only like a second mother, but a best friend, is torture in itself. The nightmares continue to invade our lives as we try to hold each other together. We worry about what happens if he would get out. Do we have to relocate, change our names, or do we ever have to face this monster ever again? For my aunt to lose her life alone due to this vicious predator, life in prison is an easy choice to be given. At the end of the day, he still will have his life, even if it's behind bars. All I can ask of you is to please choose life in prison and to give him the maximum sentence of being a violent, repetitive offender so that our family is safe. Our family, the Halcomb family, the Brewsaugh family, we want to thank everyone that's been a part of this case from the beginning to the end to the jury. That's all I have to say.
Thank you for your comments, ma'am. I do need to let you know that this statute does not give me the authority to impose a sentence of life without parole, but I will consider your comments when I make the decisions that I have the authority to make. And I'm sorry for your loss.
Thank you very much.
Anything else from the state of Ohio, Mr. Burrs or Mr. Hahn?
The only other thing I would like to say, I would like to thank the City of Hamilton Police Department for their work on this case. I know I think there's maybe 3 officers that testified, but there are many more that were part of this case, and justice would not have been served today without all their efforts. So thank you.
Very well. All right. Well, the court has considered the purposes and principles of sentencing in Revised Code Section 292911 and the seriousness and recidivism factors in Revised Code Section 292912, as well as the penalties that are statutory penalties that are associated with the offense and the specification. The court is also considering the record and the charge and the statements made at this hearing, and the court on count 1 is going to impose the mandatory sentence of an indefinite mandatory minimum term of 15 years in prison and a maximum term of life imprisonment in the Ohio Department of Rehabilitation and Correction. As to the repeat violent offender specification, the court is going to impose 10 years, and it will be consecutive to the sentence. The court is imposing the maximum of 10 years because this offense is was, quite frankly, so gruesome, and the court finds that the defendant is a danger to the public, and the court relies on the Exhibit 251 and the offenses that Mr. Madden has previously been convicted of in support of those findings. The court is going to run this sentence in this case consecutive to the sentence in case number CR 22101423, and the court is running it consecutive because it believes that consecutive sentences are necessary to protect the public from future crime and to punish the offender. The court further finds that consecutive sentences are not disproportionate to the seriousness of the offender's conduct and to the danger that he poses to the public, and the court finds that the offender's history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the offender. The court is also going to impose court costs as a part of the sentence, and the court will award 316 days of jail time credit. Are there any other findings that the state wishes for the court to make at this time?
So it's 15 years to life. The RVO is consecutive. I think that's by clause. Not any sense on the RVO is consecutive at all. And what was Judge Stevens' case number?
That is a CR 22101423.
I don't believe there's anything else wrong.
Okay. Anything on behalf of the defendant?
Sure, Judge. I don't know if this is required or not. Should there be any advisement at all about PRC at all, given the sentence? May not. I was just making sure we're clear before we left.
I am understanding that it does not because of the indefinite nature of this sentence, the defendant would be subject to parole rather than post-release control. Does the state have any objection to the court's findings? Okay.
Nothing further than.
And then the final thing that I would indicate that this defendant does have a right of appeal, and he has 30 days from the date that the conviction entry is filed to file that notice of appeal.
I will file that for him, understanding that he will have a new attorney on appeal.
Yes, sir. All right. Well, again, I thank the counsel for their professionalism, and at this time we will recess on this matter. Thank you.
Thank you, Your Honor.
Okay, there you have it. Consecutive.
All right, don't go anywhere. Don't go anywhere. I have two more things to play for you guys. One is going to be Michaela's interview, and then I found the 911, the person who called 911. Remember, we were like trying to figure out who the heck called 911. So don't go anywhere. And he's getting at least 25 years. So she said that she couldn't give him life without parole, but it's at least 25 years. So 25 years before he has parole. He's what, 50? He was 55 back then. He's 56 now, I think. He's 54. So 25 years, he's, and that's at least 25 years. All right. So unfortunately, we have to check this out. But if we can make it through this interview, this is Michaela. This is Michaela talking.
Bravely through the stabbed 55 times murder trial. In the end, watching the jury convict her father, Toby Madden, for the murder of her mother, Rachelle Brewsaugh. Michaela Madden was there every single day in the courtroom listening to the horrifying details of her mom's death. And we know that could not have been easy. She also had to testify in the case. Also not easy. And we witnessed her watching her father's first outburst and meltdown right before the jury was sworn in to hear the case. And perhaps that sealed his fate. Let's watch.
I'm responsible for what happened to her and me. I can't do it.
Judge, are we recording?
I believe we are.
Do we go off?
Do we need to take a recess?
Yes.
Okay, let's take a recess and we'll go on.
I want to welcome in a very special guest now. Michaela Madden is joining us this morning. Michaela, good morning to you. And may I say from all of us at Court TV Network, we are so sorry for your loss. How are you doing this morning?
Thank you. I appreciate it.
Always busy being a mother. Always. But I'm doing as best as I can.
Yeah. You are so strong and so brave, and I just want you to know so many people who were watching your dad's trial were admiring your grace, your poise, your strength, the endurance that you had from the beginning to get through and to continue to endure. Now it's not over for you, as we know. How did you muster up that courage and that strength?
Definitely, it's because of my mom. My mom always told me, you cannot be the sheep, you always have to be the lion.
That's great advice. We're showing.
She taught me how to.
Go ahead, please, Michaela.
She taught me how to keep your dignity.
Mm-hmm. Oh,
basically, don't let anyone, dim down your light. Thank you.
Right, right. And we have a little bit of a delay. I'm sure it's apparent to our audience, so I certainly don't mean to step on you if you hear me speaking when you haven't finished.
You're fine.
Michaela, tell me, when...
I'm trying to fix my ear pod.
Yeah, no. You take your time. When this trial was about to begin, and we saw your dad turn to you in the gallery before the jury was brought in and admit to killing your mother in so many words. He said, I am responsible for what happened. Please don't hate me. And then he still proceeded to make the government prove the case against him. Did that make you mad?
Very, very, very mad. Why would you make me go through this when you already know that you did it? Yes, it was very cowardly.
Michaela, prior to the trial beginning, in the time between the kickoff of the trial and then the time of your mother's death, had you had any contact with your dad?
No, actually, he contacted me, actually, the night before my mom's funeral.
What did he say?
He's like, I loved your mom. I wish I could have been there. We're going to figure out who did this to her.
Michaela, what do you think happened? Why do you think your dad killed your mom?
To be honest with you, I have no idea why he would want to kill my mom. That still is one of my questions of why. Why would he do this? I don't know why. I think it was a mixture of drugs, rage, just not fully there.
What was he using in terms of drugs?
To be honest with you, I have no idea. My whole childhood was a mixture of alcohol and drugs.
I'm so sorry. You have done so well. You are such a beautiful, smart, poised, strong young woman. Do you attribute all of that to your mom?
Oh, yes. She's the way that I am today. And she is the reason why I will be the mother I am to my daughter, because she taught me.
Tell us more about your mom.
Sorry.
Please, no, it's okay. It's okay. We didn't know that you were a mom too, which is such a beautiful thing. And you can carry on your mom's legacy with your daughter, as you know. Tell us more about your mom, Rachelle, please, Michaela.
Oh, I will.
Yeah.
She was such a warm, loving woman. Like, you just always wanted to be by her. She was funny. She was a great person. She was a nurse. She was always willing to help other people out. She was a great grandmother. I mean, fabulous. The one that you always wanted to come over and bake cookies or get in trouble with. My mom words can't describe how my mom was. You always just wanted to be with her. You always wanted to do stuff with her. You just had to be near her to experience how wonderful of a person she is.
And I would imagine she was very giving, if I had to guess, because I heard you in your impact statement, which was so strong and so well done, Michaela. And when you were saying, your dad would take, wasn't a good partner to your mother, wasn't a good father to you. And I would just imagine your mom was probably a very selfless woman.
Oh, very, very, very. She always did whatever she can for anyone. And that is what I will carry on with my life. I will do whatever I can for anyone and help them through whatever they need to be helped through.
Michaela, that's awesome. Tell me, what does your relationship with your dad look like from here on out?
Oh, there is no relationship. There will never be a relationship. There wasn't really a relationship growing up. He was not a very nice dad to me. I went through a lot of things that, I shouldn't have as a kid. And there will be no relationship in my adulthood. I just can't see myself doing that. You took the only thing that meant anything to me. And it was my mom. My best friend. Sorry.
No, please don't apologize. Nobody can fault you for feeling that way. Your feelings, your anger, your heartbreak, your sadness, it's all justified. And so many of our viewers were getting so angry at your dad for the way he was carrying on, the histrionics, the meltdowns. Was that for show for the jury? I'm so curious, Michaela. Was he somebody who would melt down throughout life with different things, or was that something new that he just brought for this trial?
Oh, no. There's always meltdowns. There's always meltdowns. There's always chaos. I mean, chaos with him. But also it could be a show to him, He continued to trial when he already knew that he was guilty of it. So possibly could have been a show and having those meltdowns.
Michaela,
but there's a lot of screws loose.
Appreciate all of that. I didn't mean to interrupt you there. What message, if any, do you have for anyone who is going through something similar to what you've gone through with the loss of a parent in such a brutal way? You have survived and been through something very traumatic, and we know the trauma doesn't end here. What advice do you have for anyone else watching who's lost a parent or a loved one in a vicious way, just as your mom, Rachelle, was taken?
Don't give up. Don't give up. There's always, a rainbow at the end of the road. Don't give up. You can make it through it just like I can. And that there is other people that can help you, through those tough times. And to talk about things that you have went through and have dealt with. I say don't give up, and that you can continue being strong.
That's right. Really echoing your mother's sentiments about being the lion, right? Being strong, being the lion, and you'll get through it all. Michaela Madden, it has been wonderful talking with you. We send you so much love and continued good wishes for healing as you continue being the great mom that your mom was.
Thank you.
Speak soon.
I appreciate it.
Of course.
All right, I have two more things to show you. So don't go anywhere just yet. We were wondering who called in the 911. Here, let me get my face off of Rachelle. Beautiful Rachelle there. Boy, Michaela looks so much like Rachelle. She's probably happy. She's probably happy that she took after her mother and not Toby. So, all right, I have...
Just days later, tomorrow...
I was wondering who called 911. All right, let me pull this over here again. I was wondering who the heck called 911 because Anne, the neighbor, the bank robbing neighbor, said that she heard screams. The workers left at 8:30. She heard screams between 9 and 10, and the 911 wasn't called until like noon because law enforcement don't show up until a little bit after noon, after 12. So they show up around I think 12:10, something like that. So I'm like, who the heck called 911? And then when they do show up, Toby's on top of Rachelle trying to give her CPR. So let's see who actually called 911.
Just days later, Tamara Durr is understandably in shock after calling 911 on Tuesday when she knew something here next door was terribly wrong. Now she's remembering her neighbor who was killed for her kind heart and giving soul.
She's not here. You know what I mean? It didn't save her, and it didn't make her not suffer, and it didn't stop what happened to her.
As she stares at the home that's been next door for years, Tamara Durr is in disbelief.
I just hate that this happened. I mean, it's awful.
It all began on Parrish Avenue Tuesday. Hamilton police say 50-year-old Rachelle Brewsaugh was found stabbed to death on the floor of this house.
I personally haven't seen inside, but I mean, I can just imagine. And she didn't deserve that.
Durr dialed 911 immediately when her instincts kicked in.
My neighbor next door thinks that he'd come out screaming out of his house and he thinks his wife is dead in bed.
According to this incident report, no arrests have been made yet, but Brewsaugh's death is being investigated as a homicide.
Rachelle's a very good person. I mean, she was a nurse. She, was the ones that come to your house to help people, and this is really unfortunate.
It's unclear what happened behind closed doors. Now this quiet street sitting tonight with little answers.
There's no winner. I mean, there's just it's unfortunate. I just hope they find out who did it, what happened, and just have closure for the family.
We reached out to the Butler County prosecutor on Tuesday asking if this was a homicide. He would not comment on this matter. Today, when the coroner ruled it was death by homicide, we reached back out to the Butler County prosecutor, but he would still not comment. Reporting in Hamilton, Rachel Hersheimer, WLWT News 5.
So we did not hear from Tamara. Right, that was her name, Tamara. She was not called to the stand, which is really interesting. Usually they call the 911 to the stand. All right, I've got one more final thing. This has nothing to do with this trial, but it is something that's happening right now that I just want to just kind of end with this, and then we'll call it a day. All right, so if you guys didn't know, there is a solar eclipse going on right now. This is Spain. This is Leon, Spain. So 2 minutes and 30. It happened already, so I just want to check out the last couple minutes of this, of the totality of this. Well, here, let's see. This is where it's happening.
Be experiencing totality, and it will be getting about 1 minute and about 44 seconds of totality, which is so exciting. The path is going to be hitting several other towns as well, such as Mallorca and Villalobado, and the view that we're seeing right now is of Leon, Spain. And even though totality hasn't occurred yet, you can see a tiny little filament, or prominence, on the one side. Okay, so remember to be safe when watching a solar eclipse. You have to be wearing safe solar viewing glasses or use an indirect viewing method.
Since it already happened, they're going to tell us where. Let's see. I thought there was something where they say, oh, here, this guy. All right, this is where it's happening.
In northern Siberia, and because they're so far north, that eclipse starts at midnight. They are well above the Arctic Circle, so the sun is up 24 hours a day. And then the other kind of odd thing about it is this north-south path. Most eclipse paths, most totality paths are west to east. But this one, because it's so close to the pole and because of the orientation of the Earth and the fact that it's a descending node eclipse, it's starting in the north and going to the south and then suddenly making this left turn into Spain. So we're looking forward to seeing that total eclipse in Spain where the weather looks great. Back to you, Joy.
Thank you so much, Ernie. So we're about 15 minutes away from totality.
So Pete Cooper and Heidi, were you guys able to actually see it? Was it too cloudy for you guys? Were you actually able to see it, or was it too cloudy?
But one of the cool things about our technological society
California
today
will not
is
see
you
it.
get to see many more of these things, whether it be...
No, California, the East Coast, like I think it was, hold on. California was not able to see it. It was more for the East Coast. Toronto was going to be at 140. New York City was at 154. So, yeah, it's already happened. And yeah, the West Coast of the United States was not going to be able to see it. The East Coast barely, and it was like partial, like 30%. It was like a 30%.
So as you can see in the bottom part of this video, the moon's shadow is just about to reach Spain. We're about 3 minutes out from totality hitting Spain. Leon, Spain is going to be experiencing totality, and it will be getting about 1 minute and about 44 seconds of totality, which is so exciting. The path is going to be hitting several other towns as well, such as Mallorca and Villalobado. And the view that we're seeing right now is of Leon, Spain. And even though totality hasn't occurred yet, you can see a tiny little filament, or prominence, sorry, on the one side. Okay, so remember to be safe when watching a solar eclipse. You have to be wearing safe solar viewing glasses or using...
So Pete Cooper, you saw it, but it's only 92%. Oh, okay, we don't need the safety reminder. 92%, so more twilight than full dark. And Heidi, it was bright, and we could have gone to the beach, but stayed home. We have seen 1990, you saw one. Very cool. The light was amazing, Heidi says. Shannon, you are welcome. Yeah, no, it's, I kind of wish we had done a separate stream for this, because you know how much we like space. I wish we had done a separate stream. I totally forgot about this until like 2 o'clock. I'm like, oh yeah, that's right. Or it was actually like 1:30, but it's all right. We can experience this together. So this is in Leon,
so
Spain.
These are things that are very interesting and again can erupt in the space weather that we were talking about earlier. So this is a great view. And even with this, you know, it's not complete darkness. That little bit of sun.
Yeah, you can totally see the flare there.
We can see the crowd.
Wow. So we're about a minute and a half away. What should
Yeah, I see the flare right there. Yeah, definitely.
Hits? So what they should see is what we call the diamond ring effects, or the Bailey's bead. So these will be really bright lights, and it's from the last bits of sun coming through the moon's valleys. So that will come through, and we'll see that. And you still need your eclipse glasses or an indirect viewing method at that point in time. But then once that's done and you're in the path of totality, it's time to remove those glasses and see the corona with your own eyes.
Wow. And if you're on the ground, what other sensations will you be feeling?
It will definitely be getting colder. There might be a wind. You could, again, change in animal behavior, any wildlife that's around you, and really the sense of awe, as well as the 360-degree sunset all around the horizon. So just a few things to look for.
Wow, this is a stunning view. We have just a slither left, and this is the moon covering the sun's disk. And when totality occurs, that slither will disappear. We're about 30 seconds away now from totality in Spain. If you're on the ground and you have clear skies, we are so happy for you.
Yes, definitely.
Wow.
It's just beautiful. And again, probably feeling so much excitement. And sometimes you even feel a little fear. Like I think was mentioned earlier, they felt it was eerie almost. It's an eerie light. It's not something that we're used to in a human experience. But here it goes. It's we're getting close to those Bailey's beads or the diamond ring effect. So those should be coming very shortly.
Wow. All right, totality is almost there. The slither is about to disappear. Okay.
The little diamond ring.
Wow.
Yeah. All right.
Totality has hit Spain.
Yes.
Oh my goodness.
Lovely view.
What is the red mark that we're seeing on the image right now of the sun?
So the red mark is that filament. So it's a bunch of very hot material that has been hanging above the sun and just kind of hanging out there based on the magnetic fields of the sun that keeps it kind of in a little magnetic cage. Oh, look at that. That's a really nice view of the corona. You're seeing things that look like streaks coming out of this, and those are streamers. So that's the basis of the solar wind that we are bathed in constantly. The sun is constantly outflowing material, and so that's that constant stream. And then you see the what could become a big chunk at some point in time in the pink filaments that you see there.
Wow. So we see that coming off of the sun. So this is the atmosphere of the sun's corona. Are those streaks that you just mentioned, are they coming towards Earth as well?
They are coming towards Earth. So they fill the entire solar system, or the heliosphere, which is actually all that the sun encompasses with that solar wind. So it's the entire solar system, so it definitely hits us here on Earth.
Wow.
And this is absolutely beautiful. Again, you're seeing a prominence also on both sides, really, and maybe even one up on the other corner.
Oh, wow, yeah.
So there's lots of, even though the sun is supposed to be towards a minimum of activity, which meaning you should see less of this, we're seeing more of it. And this is one of the important reasons why to keep studying these eclipses, is to see what is actually happening on our sun. When we think we know what's going on, it seems to change it up a little.
And what is it about these features that are so important to study?
It's important to study what they're made out of. Oh, and now we're back to the diamond ring. So we're coming back out of it already. It was always... Oh, wow. Yes, it happens so quickly. And once you see one, you definitely want to go back and see some more.
Wow. So totality has ended.
Yes.
In Villabado, Spain. Wow. So you're telling me that we also see the diamond ring and Bailey's beads at the end of the eclipse as well?
Yes, exactly.
Wow.
When you're going into or out of the eclipses.
Okay, so this is a view from Valora La Buena in Spain as well. They are seeing an eclipse right now. Eclipses happening in Spain are about a minute apart from one another in these telescope views. So they're seeing totality. So the red mark that we're seeing right now, is that another prominence?
Yes, those are prominences, that material that is suspended above the sun that's very, very hot. Again, it's interesting to us to know what they're made out of. There's normally filters, like here and on the airplanes as well, to tell us about whether that's some iron or whether that's carbon or oxygen or what exactly is those pink filaments made of.
Wow. And you can see the moon is moving away from the sun right now. What is it that we're watching?
Yeah, Bailey's beads. And so these are the beads, and so now we're actually going out of totality again. So
wow, what a brief moment of totality.
Yeah.
This is just amazing. They have had clear skies, and this is exactly what you want for a total solar eclipse. Yeah. Wow. This is Mallorca in Spain. Oh my goodness, this is stunning.
Wow, yeah.
Look at that corona. Why is it so much clearer? Why is the corona so much clearer during a total eclipse?
Yes, yeah. So it's so much clearer because you're taking away all the bright light from the face of the sun. The sun is very, very bright. So it's basically a million times different. And when you blot out that middle, you can see all the beautiful things that are going on behind it. And so, yeah, so this is the beautiful crescent moon that you're seeing. I think previously we were seeing those strikes of light. That's also closer to sunset there as you go more south in Spain. And already the light's returning, and they seem to be very excited in the crowd there.
Yeah.
It's such a great feeling to experience those eclipses, even though they were so short.
Wow. And experiencing a total solar eclipse, that is completely different to a partial eclipse.
It really is. And it took me, even as a heliophysicist, it took me a while for them to convince me that I should do it. And once I saw my first in 2017, I've seen multiple since, because it is a full body experience. It is very different than seeing just one bite out of the
It is pretty cool. So that was This was about an hour ago, about 1:55-ish. Yeah, a little bit over an hour ago. This happened.
Well, that was an incredible solar eclipse. What a view. I am eclipse. Beautiful sight during an eclipse.
This is Palma de Mallorca.
We could see the sun's corona so clearly. And we could even see multiple prominences as well from the sun, which is a beautiful sight during an eclipse. So in a few minutes, we're going to be speaking with a NASA astronaut live from where they saw a total eclipse. But first, let's go back to the poll that we posed to you earlier on in the show.
All right, hold on. We don't need to. Thank you, Debbie, for your support. Really appreciate that. All right, let me back up a little bit. I think I think the space station got involved in this too. See what these guys have to say. Wait, hold on. I thought oh, that looks pretty cloudy there.
We actually learn about the sun
was
during just a
37
few minutes
out.
of totality compared to years of normal observations.
Sorry, I'm just trying to see. I thought that they were talking to the people on the space station, the astronauts on the space station. Oh, here's one coming up in
clouds. Look, Iceland is very cool in Spain, a lot of the observation locations for this one, but in Egypt, in the Valley of the Kings, is going to be an amazing backdrop.
And that is going to be the longest total solar eclipse of the 21st century. It is over 6 minutes. To stand in somewhere ancient is particularly moving.
Oh, that'll be a good one. August 2nd, 2027 in the Valley of the Kings. Ooh,
It's the one thing you want people.
that will be spectacular. All right, okay, here's some folks on the
So
space
let's learn
station.
more from my colleague Abby Unterante, who caught up with the astronauts on the space station a few days ago.
Well, hi, Jessica and Anil. It is so great to talk with you. From the International Space Station, you see Earth and the solar system from a unique perspective every single day. Thank you so much for joining this long-distance call to talk about this moment.
We're so happy to share this with you.
We study the sun and its influence on Earth and throughout the solar system through a field called heliophysics. What is the benefit of studying the sun from up there in low Earth orbit?
One of the big things is that there is a lot of particles that are around Earth, and those particles can be affected by coronal mass ejections, and those ejections can energize the particles and affect things that are in space. And the things that we care about in space are satellites, and those satellites give us communication, they give us internet, and so there's even a future where we have data centers in space, and we're using the sun's energy to power things like artificial intelligence and things like that. And so we need to understand how that's going to be affected by the sun.
If you could pick anyone, who would you want to watch an eclipse with, and would you rather watch it?
All right. I thought that they had a view of them, but I guess not. All right. So now it's
stand back and you watch the launch or you watch the total eclipse. They're both kind of in the same category in that they only last a couple minutes in terms of what you could see, and it's better to view them through your own two eyes than through the viewfinder on a camera.
Okay, good tip from a NASA astronaut. So how did the experience watching this from the ground compare to watching an eclipse from space, which I know you've done a few times?
I've had the opportunity to see 2 solar eclipses from space, and in space you look at the shadow projected on Earth. You don't look at the sun itself, and the shadow has all the detail that the classic astronomers from hundreds of years ago predicted. You see the umbra, you see the penumbra, you see the shadow moving over Earth, and it's a vantage point from space that you can't see from Earth.
Wow. So lucky. And I know you've seen a lot of other beautiful phenomena in space, like the aurora and...
All right, so that's it. Then they sign off. But anyway, so that's I guess that's a good way to end and honor Rachelle. Hopefully she was a space lover and watcher of the stars. So maybe that was a nice way to honor her in her memory. So, all right, you guys, we're going to call it a day. And August 2nd, 2027, Valley of the Kings in Egypt. Mark your calendars. We will definitely stream that. We will absolutely stream that for sure. And there's going to be a Orion Artemis 3 launch next year as well. So they're only going to be in low Earth orbit, but then I think in 2028 they're planning to go to the moon. So we definitely have some cool space things coming up next year. And I'll keep my eyes out. Maybe there's another eclipse going on. I'll have to see what's going on. So, Aussie Gardner, thank you. Northwest, have a good night. Kaylee, Little Lulu, thank you guys. Yes, Camilla, if you need to say your goodbyes and head out early, now's the time. Let's give Chris our full attention for the announcements and closing remarks. Thank you for spending the day with us. Thank you, Camilla. I really appreciate that. So programming note. We have some really, really interesting things to show you about the Mario Fernandez trial. Really, really interesting. They're doing jury selection right now, and we will bring you some of that tomorrow and Friday. I'm not sure if I think we'll do both days. I was planning on doing Dwayne Davis, Keefe D, doing a deep dive on him tomorrow, but we may save that for Sunday. I'm not 100% sure yet. If we have enough content for 2 days for Mario, we'll do that. If not, then we'll do Keefe D tomorrow and then Mario on Friday. But we're definitely doing Mario Friday, regardless of whatever happens tomorrow. So yeah, there's some really, really interesting things. They're going through jury selection right now. So look for that. And thank you for watching the Toby Madden trial with us. Mario starts Monday. And it's going to be a good one. It's definitely going to be a very interesting trial for sure. So with that, thank you to our mods. Thank you to Aaron. And thank you to you guys for watching and spending your day with us. And hopefully you will have, I know it's early, but I've got some things to do on the back end. I got to get ready for this Keefe D. I got to get ready for Mario. So I'm going to take this opportunity of ending early to work on those items. So with that, have a fantastic rest of your day and your evening. And join us tomorrow. Not sure if it's going to be Mario or if it's going to be Dwayne Keefe D. Davis. So that's the Tupac, associated with Tupac's murder. So with that, have a great day, and we'll see you guys tomorrow.